And to dispose of the matter, already 10 times matter was adjourned, thereafter Lordship was disposed of. For that, nothing but 2 minutes for matter to dispose of matter.
Which one? It was disposed of.
No, the Lordship's writ order is challenged before Lordship, that opportunity not given for hearing.
Kaha order challenge ହେଇଛି ମୋ ପାଖରେ?
ମାନେ ହାଇକୋର୍ଟ ଅର୍ଡର ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ଆମକୁ ଶୁଣିବା ପାଇଁ ଅପରଚୁନିଟି ଦେଲେ ନାହିଁ ପ୍ରାୟର ଟୁ ଡିସ୍ପୋଜ
ଦିଅ
10 times
My lord, matter is related to RSA for 23. In spite of filing of several members, the case has not been passed. Fresh admission.
Fresh matter of second appeal. You'll also kind of matter, my lord.
Fresh matter.
Yes.
My lordship, this is for the petition filed for bail, interim bail, and
Quickly tell you item number 1, trace admission.
Wait, please, the lordship.
Yes.
My lord. The petitioner is the husband in this case.
Yes.
The petitioner seeks a transfer of the 490-day case, which has been filed by the wife.
Yes.
Alleging petitioner and in-laws, but the in-laws have not been charge sheeted.
Yes.
My lord, the ground is that he apprehends danger in that place.
Yes.
Relating to this matrimonial dispute, your lordship, 2 other TRPCR and 1 TRP is filed. One, the domestic violence case has been filed by the wife before the Nyadhikari Ottavira, Gramanalaya Ottavira.
Yes.
Seeking transfer of that domestic violence, the husband has filed TRP-CRL number 100/2019. This honorable court has been pleased to issue notice and state that matter.
Yes.
Now the husband filed a divorce case in the learned judge, before the learned judge, family court Bhubaneswar. Since the wife is residing at Bargad, the wife has sought for a transfer from Bhubaneswar to Bargad, your lordship. That is TRP-C number 279/2019, 273/2019.
All right. List this matter tomorrow along with TRP. Yes.
item number 2.
My prayer is that, your lordship, now
let it come tomorrow.
all the cases be transferred to Bargad.
Let it come tomorrow.
My lord. Okay.
Lordship, this is for transfer of the proceeding before the learned authorized officer Bhubaneswar to Cuttack. The ground is that, lordship, the petitioners are facing a confiscation proceeding.
Yes.
And the case is at the stage of argument. Lordship, may kindly see Annexure 2. When it is fixed for argument, the order sheet, lordship, may kindly see Annexure 2. The learned authorized officer has called for a report regarding the market value of the property. The consideration of market value arises only when there is confiscation. So the authorized officer has come to a mind that she will confiscate the property. So what further argument I will do, Lord?
That is not a ground. You challenge that order. You challenge that order in a revision. You challenge that order in a revision. That is no ground for transfer at this stage of argument. And that too from
Lordship, he has.
No, Mr. Moon, I am not inclined. You challenge this order. It is open to you to challenge this order before the appropriate forum in an appropriate application, but transfer on this ground will not be allowed.
Notice that no. Se mo ghor napiba pai aji mote notice korichari kali notice korichari.
You file a revision and pray for stay of that order or whatever challenging that order. It's open to you to challenge that order.
Kindly see section 15. The consideration of the market value arises
I do agree.
only when there
that cannot be a ground for transfer. That is what I'm saying. I'm not saying, I'm not commenting anything on the legality or
I will not get justice at the end of the court.
How can you say that? You are indirectly casting aspersion on the judicial
lordship on the ground that she has made up her mind to confiscate it.
No.
That is why
this is too far-fetched an argument to accept. No. The judicial officer, why should he have any personal, he or she rather, why will he or she have any personal interest in the matter? She may commit a mistake, a bona fide mistake. That's a different matter. You can challenge it before this court. You can get it interfered. So I will not interfere in this matter. It's open to you. Either you withdraw or I will pass the necessary order, whatever you decide.
No mistake has been committed by the learned authorized. My lord, I am to submit only one line.
Under section 15, the learned authorized officer will confiscate the property. Scope is given to the delinquent if he deposits the market price of the property to be confiscated, then this property shall not be confiscated.
No, but Mr.
Scope is given to them. So the learned authorized officer has responded.
Maybe, but this court will not express any opinion.
Yes, he has already been convicted in the trial.
Anyway, that is up to you. Yes, sir.
So withdraw.
Permitted to withdraw. Yes.
LAPL, your lordship had posted to today. It has not been listed.
So,
That operation will not.
आज की थी ना बता ओ से जो बंद हो गया कोर्ट अच्छा What is the urgency, Mr. Panda?
But now he has been advised for getting admitted for the operation. Unless he is admitted in time, my lords, then again
When is that operation due to be?
he believe he has been asked to get himself admitted on the 11th of.
So there was some order passed in that case, or there
Yes.
was another case.
You know, your lordship granted him interim bail for the tests and he surrendered. After he surrendered, your lordship directed the state to take instructions and it was posted to today.
Yeah, it is because of yesterday.
Yes.
That problem. Yes. 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 Item 3.
Item 3, my lord, your lordship has passed the order for inclusion of the old pension, the pension disposal. That is
Yes, my lord, it has already been disposed of by
disposal
the
of
court.
similar matter.
Without entering into the merit of the case, representation has been directed to be disposed of by the authority.
The same.
Same, sir. Both are same.
Both the cases are.
No, when did you submit a representation?
So that is date is different.
को correction कर देंगे है ना correction कर देंगे all right give the date and same order
Annex 3,
चेंज लिखी कर दियो
both the cases are.
both the cases are same ताले से आरो केस रे के केबे को डेट रे दियाई रिप्रेजेंटेशन से डेट दियंतु दिना गल गल के डेट लिखि दियो yes item 4
On that last occasion, your lordship directed the Learned State Council to obtain instruction.
I have received a parabolic comment in
चलो
this
अपने
case.
इशू कर दो
The active of the case in nutshell is that the petition.
no you will file a counter
Yes,
let him file a counter there is an interim order in your favor
yes.
all right Sri Asan Patang Learned AG submits that he has received the parabolic comments and would file a counter shortly next week in the meantime
2 weeks.
what 2 weeks you have the ready you are ready with the parabolic comment why 2 weeks
They have to comply the.
what call
23rd July.
Huh?
23rd July.
23rd July call it let's just matter on 23rd July counter affidavit if any be filed in the meantime after serving copy on the other side interim order shall continue till the next date
Item number 5.
This is covered by Dhananjay Charan the case, man. I've supplied similar.
all right
Also, they corrected. 5 and 6, sir.
individual or
Individual, man. Yes,
no,
individual.
the petitioners are individual petitioners or
No, batch case.
batch cases all right same order will be passed but individually they'll have to submit representations yes item 7
Item number 7.
Final item number 7 kindly pass over.
all right pass over
Item number 8.
I beg your pardon, madam. Mr. On behalf of Mr. A.K. Nando, 2 weeks may kind of
Item 8.
kindly be allowed for filing the substitution petition.
Item 8, probably you are making a mention out of this weekly list. This is a weekly daily. I don't think this is your matter. Yes,
Beg your pardon, my lord. Item 8 kindly be passed over.
pass over.
Pass over.
All right, pass.
Item number 9.
In item 9, your lordship had directed me to produce the records by which the annexer, impugned annexer 3 has been passed. I have talked to the director. He has honestly requested for another week's time. They are making all search.
Paramesya case, kindly have a glance your lordship's last order.
All right, all right. I'll pass appropriate order, don't worry. The DGA submits that the required record has not been able to be obtained. List this matter on 12th July. The Director of Higher Education shall appear in person along with the record and file an affidavit as to why necessary action shall not be taken against him for non-compliance of this court's order repeatedly. Yes.
May I pray, this order will be passed on 12th. Because he has honestly requested me.
No, Mr. Das. No. No. He should appear. What is this? You can't take the court for granted.
No, that
You can't take the court.
they won't dare to.
No, no, they will. I know. And sometimes we are responsible for it. But I can tell you, I can be very, very harsh. I can be very, very rude and very, very harsh. If I find that the institution is being, the dignity of the institution is not being protected, I am the last person to tolerate it.
No, that they won't dare.
No, let him appear and let him file an affidavit. Why action shall not be taken against him? If necessary, I'll issue a notice of contempt on that day, on him. Yes.
Item number 10.
Item 10, pass over.
Item number 11.
Today I am filing the amendment application. Your lordship may permitted I file. Otherwise I am file.
You are filing the amendment petition?
Yes,
All right.
along with the consolidated rate
Learned
application.
counsel to the petitioner files an IA seeking amendment of the writ application in court. The IA be registered. Copy of the IA has been served upon the state counsel. You would like to file your objection or say something about it?
No.
No.
Because actually there is a mistake and one prayer has been omitted. So it is why my lord Appellate pointed out that
It is submitted that the prayer portion needs amendment in order to incorporate a relevant relief claimed, relevant relief, as the same was left out due to inadvertence. Learned State Counsel fairly has no serious objection to the amendment being allowed. So, as such, the IA is allowed. Consolidated writ application has also been filed in the court. Same be kept on record. Yes. Place this matter on Kebekoro.
Next week.
All right, next week let it come.
Yes.
Next week, how Yes.
16th.
Yes.
Okay.
Item number 11. Item number 12.
Yes, item 12.
Okay.
Matter yes, not the passover. Yes.
Item number 13.
My lord, petitioner a lecturer, although he is entitled to get selection grade scale of pay with effect from 1992, he has extended.
You were supposed to cite some decisions.
Yes, ma'am. I have brought that is your lordship's decision. Yes, I am giving it.
That Ashok Mathi's case.
Yes, ma'am.
What is it?
Squarely covered.
How?
That's why I will please, ma'am. Right. May I please, ma'am?
Yes, please.
Before going to the read, I would like to draw your lordship's attention to the counter affidavit. Counter affidavit, they have admitted the facts. That is why I am drawing your lordship's attention to the counter, page 2, in internal page 2 of the counter.
Yes.
From the top, my lord, he continued to serve a government college till 13/12/75 and faced retrenchment due to non-recommendation by the OPSC. Thereafter, the petitioner joined on 2/1/76. This is important, my lord. As lecturer in zoology in Rairangpur College, Rairangpur, which is an aided non-government college. As such, his services has been taken into account with effect from 2/1/1976. So they are not disputing this. Thereafter, I am drawing your lordship's attention that to the law that after completion of 8 years, senior scale of pay, next 8 years, selection grade scale of pay. These are not disputed. So 76 plus 8 plus 8, it comes to 92. I am entitled to 92, but they taking recourse to that amendment in section 7C, they calculated it from 8 plus 8 plus 5 years. That is the factual aspect. That law has been dealt with by your lordship in that judgment, that we cannot be differentiated non-aided college teachers, because
There I found a violation of Article 14.
Yes, I have written
Certain
completely.
persons had been given the benefit,
Yes.
and these people were discriminated. So
Discriminated.
probably I held that you can't create a class within a class.
Yes.
So what has happened to that judgment?
No action has been taken, my lord.
Whether it has
We
been
have not-
implemented or it has been challenged?
They have referred the matter to the law
Law
department.
department.
and Yet we are yet to receive any.
If they are going to take any action.
No. Why should we keep it pending?
Yes.
Why will I keep
This
it
can be
pending?
dis-
Squarely come.
If you cannot obviously concede,
No.
but whether it will be proper to dispose of it off in terms of this, or we have to file a complete judgment. That is what is to be seen.
They were supposed to file an additional affidavit.
Who?
According to last order.
Who?
Okay, sir.
You are appearing for whom?
So for commendation.
No. This is another case possibly. Upon our list of the.
ଆପଣଙ୍କର ପାର୍ଶ୍ୱ over
Oh,
ହେଇଛି।
this is 13. Sir, pass over age, 12 time.
The password is wait karo. Wait karo.
Sorry.
I was going through a lordship judgment, entirely squarely covered. My case is squarely covered.
But a judgment has to be passed. I don't think it can be simply disposed of by saying that it is covered by.
No, your lordship may render the judgment.
Yes, what do you say?
Yes.
What are the facts then?
And another fact that as to whether it has been extended to me or not, it has been extended to me from 1997. That I reflected in the rejoinder.
See, 5 ବର୍ଷର add କରିଦେଇଥିବେ।
କରିଦେଇଛନ୍ତି ନାଇଁ କେତେଟା କେସରେ ଦେଇନାହାନ୍ତି, he is entitled to get it. In my case, I have already received it from 1997. That is how it is squarely covered.
Then you challenged it in 2003.
Sorry, what?
You challenged it in 2003. You didn't challenge it at the.
Yes, there is no dispute about all those things. There is
So
no
will the delay not stare at your face, Mr. Das?
on the last occasion, your lordship questioned that, and your lordship took expressed an opinion that limitation should not stare at.
No. Ordinarily,
your
it would not.
lordship's opinion on the last.
But here, you must satisfy the court. In that case, what in Ashok Manti's case, they were litigating right from the beginning.
Yes.
If I remember correctly, there was a batch of cases, and they were litigating right from the beginning.
Yes.
In your case, if you have that kind of a thing, maybe, but your representation annexure 1 is made in 2003.
Yes.
It would be difficult.
Now I'm leaving it to your lordship.
No, it will be difficult.
Whatever.
This delay will stare at you. Let us see. When did you get your?
Just the reverse opinion. Last occasion, your lordship.
The court can pendulum sometimes this side, sometimes that
It has
side.
not been written, but that language I forget. Loud thinking.
Yes, loud thinking, maybe, but probably I did not. I wanted on your submission that you will submit, you will furnish this judgment or any other judgment.
Yes.
The matter was adjourned. Now, what I find now, the judgment cannot be mechanically, lock, stock, and barrel cannot be applied because of the delay.
I don't say that mechanically applicable. I only submitted that factually it is squarely covered.
The principle is covered.
Yes.
The principle is covered.
And about that limitation, that delay in approaching, I approach the authority at right time.
Where is that? Where is that? That is what I would like to know.
I approached the authority, but I didn't get the benefit then and filed it subsequently.
Say it, Dr. Where have you? Let us come to your writ application. Where did you? When did you get it? 1997.
97. I am entitled to get it from 92.
সেটা কোন জায়গায় লিখছেন আপনি?
Rejoinder ଦେଇଛି মানে ପାଇଛି 97 ରୁ ବୋଲି I have written in the rejoinder.
Placement in selection grade 2192.
Yes, my lord.
So first you have to get senior scale. Thereafter selection grade.
Yes,
Which is the reader scale? Which is the reader scale?
हाँ, reader scale जार नहीं PhD नहीं selection grade. ସେଥିରେ dispute କିଛି ନାହିଁ. ମୁଁ after completion of 8 years I got this senior scale. ସେଥିରେ dispute ନାହିଁ.
Where have you said that?
Yes, my lord. Para 1 of the rejoinder.
Para 1.
Para 1 of the rejoinder. That the petitioner in this petition has said declaration so wherein the prayer of the petitioner for placement the selection grade which performed 92 has been turned down and he has been allowed the selection grade of the scale of pay with the performed to 190.
This is what stares at you. So there's a delay of around how many? 6 years.
Yes.
I mean, you approach this court. So in between, if you, submitted any representation, that is what the court would like to know.
That's what I have written in the petition, but document I have not acknowledged. Document I have not acknowledged. And ମୁଁ ତାକୁ ପଚାରି ପାରୁନି, if your lordship remembers, he is in Niman's ପୁରା unconscious stage, ତାଙ୍କୁ କିଛି ବୁଝି ହବନି.
No, ठीक है.
That what submitted earlier. I wanted to take that instruction from him, but say ତାଙ୍କର family members କହୁଛନ୍ତି he is not in a position to answer anything.
Because this law, the provisions have been interpreted.
Yes.
Interpreted to mean that you can't discriminate between
Yes, ma'am.
two sets of employees, those selected through by the management and those by the state selection board.
State selection.
You are from the management
Management.
side. So in that case, they gave a list of persons who were given the benefit being selected by the state selection board.
Yes, ma'am.
Their plea was that since from the very date they received the grant in aid, so there is no question of deducting 5 years.
Right.
Again, it comes to challenging the amended provision. It should have been challenged. It has not been challenged. Whatever. It has stood its ground, as they continuously say in their counter, that it has stood its ground for more than 23 or 25 years. Isn't it, Mr. Patnaik?
Yes.
How to get over? How to get over your delay? That is what I would like to see. Where have you said in your writ application that you represented, or in your rejoinder?
No, in the writ petition itself, my lord, it has been submitted.
Submitted.
He has made representation for the.
Where is it?
The general also include annexure 2
Annexure. Acha.
and representation.
It bears no date.
But he has
Yes.
he has claimed that he has submitted to registry post, that is para number 9, my lord.
So that was answered. No, it's all right. That was answered in annexure 3. Come and see.
Yes.
So this gives him a cause of action. All right. Yes. You are saved, Mr. Das.
But this was also in the year 2003.
Oh, he has filed this writ application in 2003.
Yes.
This was rejected on 27/5. The writ application was filed on 8/8/2003, within 3 months.
Yes.
All right. The petitioner has approached this court seeking the following relief. The petitioner's case is that he was initially appointed as a lecturer in zoology on 30/8/1972 in MPC College, Varipada, being appointed by the management of the said college. I am writing management.
Yes,
How is the managing committee? Is it that?
Same thing.
He was transferred to Dhankanal, where he joined on Dhankanal College, where he joined on 17/8/2073. He served in such college till 13/12/1975. As he could not concur with the PSC, and as his appointment was not concurred by the PSC, OPSC, the petitioner was relieved from Dhankanal College on 13/12/1975 and was directed by the Director Higher Education Orissa to join in Rairangpur College on regular basis. Accordingly, he joined in said college on 2/1/1976 and continued till 3/3/1983. While serving in Karanjia College, the petitioner received the first career advancement scale, that is senior scale, lecturer senior scale of pay with effect from 1/1/1986. The petitioner approached the authorities for grant of further career advancement scale, that is selection grade, time and again, but no action was taken. Eventually, he was granted selection grade scale of pay. Okay,
2/1/1997.
with effect from 2/1/1990. The petitioner submitted several representations. His representation, one of such representation, dated 1/11/2002, was rejected by the deputy director, by the directorate, by the directorate, by letter dated 27/5/2003, stating that he is entitled to the career advancement scale with effect from 2/1/1997, subject to fulfillment of the requisite conditions as per Odisha Education Amendment Act 1998. Feeling aggrieved, the petitioner has approached this court in the present writ application with the above prayer, with the prayer as quoted above. This resolution becomes no longer relevant, which you have quoted under Annexure 5. See, it only says what is the qualification,
Yes.
how many refresher courses you have to.
That was in the year 1989.
It has not been taken away. That amendment only speaks of the principle, the deduction.
Yes.
And relating to the retrospective effect with effect from
Yes.
1986.
Counter affidavit has been filed by the
There are some factual incorrect data, my lord. May I be permitted to?
yes,
place?
please. We'll correct it. Correct order pass karo.
My lord, our stand is that, my lord, initially he was engaged on ad hoc basis in a government institution. And he was retrenched from 1972 to 1975. Thereafter, my lord, in 1976, he was, in fact, my lord, he was retrenched.
Yes, that you have stated in your counter.
Counter.
So what? So that is his, whatever he has said in the
Yes,
writ application, I have said that.
Our factual.
So this is not the finding of the court.
No, my submission, my lord, that what it has been submitted factually to count it from 1972, we have calculated it from 2/1/1976. That is the only submission my lord, from our side.
I note claim from 70. I came from
Submission does it.
In area, argument nahi jiwa.
Sure.
The counter affidavit has been filed by the opposite party number 2, wherein it is stated that the petitioner initially joined as lecturer in zoology on 30/8/1972 on ad hoc basis in MPC College Baripada, which is a government college. Stop. He continued in said college till 13/12/1975, when he was retrenched due to non-recommendation by the OPSC. He thereafter joined in Rairanpur College on 2/1/1976, which is an aided non-government college. As such, his services have been reckoned from 2/1/1976.
And it was
The other,
this next line, the dates are also relevant. He has been placed in senior lecture.
he was granted senior lecturer scale with effect from 1/1/86 in accordance with government resolution dated 19/3/1990. A repetition also. It is further I've heard that as per Odisha Education Amendment Act 1998, the petitioner would be eligible for placement in the reader scale with effect from 2/1/1997, subject to fulfillment of requisite conditions to be considered by the screening committee. The principal of the college was called upon to submit the proposals, but no such information was received. Anything else?
No matter.
That is common substance is this. Paragraph 90 upon sum up कर दीजिए. It is there
from 1997.
on such basis it is stated that the petitioner's claim for grant of selection grade with effect from 1/1/1992 is not tenable. The petitioner has filed a rejoinder stating that he was allowed selection grade scale of pay with effect from 2/1/1997. The amendment to section 7(C) has been referred to by the petitioner, has been questioned by the petitioner in view of the legality of its retrospective application. Stop. That's all. Third Sri Bimbisar Das, learned counsel for the. You are appearing. You have not filed your counter. Okay. We'll take you. Refer to your name. Third Sri Bimbisar Das, learned counsel for the petitioner. Sri S.N. Patnaik, learned AG for the state, and Sri Pavitra Kumar Naik, learned counsel appearing for the management.
Principal. Okay, number 3.
For the principal of Kuchinda College, bracket opposite party number 3. Sri Das would argue that notwithstanding the amendment to section 7(C) of the Act, this court in a batch of similarly placed in a batch of cases relating to similarly placed employees, that is Dr. Ashok Kumar Manti and others versus State of Odisha.
Sir, a batch of case. These case dispose of it like gote case to recall.
Batch of cases no this is your detail लिख लीजिए. कौन लिख लीजिए? Das has. Has interpreted the amended provision interpreted the amended provision and held that it does not permit discrimination by the government between employees appointed by the management and those appointed through the state selection board. Sri Das further argues that the petitioner's case is squarely covered by the ratio of decided in Dr. Ashok Kumar Manti Supra. Sri S.N. Patnaik would argue that as long as the amended provision has not been declared, has not been struck down, the same has to be given effect to. Stop. Moreover, such amended provision has stood the ground for more than 2 decades. Sri Naik, what is your stand, sir? Sri Naik would argue that the college can have no specific stand in the matter, as it is for the state government to decide the entitlement of the petitioner as claimed. There is no dispute that the petitioner had initially joined in a government college with effect from 30/8/1972 and was also transferred to Dhanagar College. But his services were retrenched because of non-recommendation by the OPS. After some time, he joined in a non-government aided college, that is Rairangpur College, on 2/1/1976. Thus, for all practical purposes, said date is the date from which his entitlement to the career advancement scale is to be reckoned. According to the petitioner, he would be entitled to the senior scale after rendering 8 years of service as per the government resolution dated
4/10/1989.
Aye?
4/10/1989.
4/10/1989. But Madhav Mishra case this court was interfered with.
Yes, ma'am.
Further, he would be entitled to the selection grade. No, would be entitled to 8 years. Thus, he would be entitled to reader scale with effect from
92. 2/1
মানে ইয়ে স্কেলটা সিনিয়র স্কেলটা কেবে হচ্ছে আপন
সিনিয়র স্কেলটা হচ্ছে যে 76 8
72 হলে 8 হলে so
84
2/1/1984. As such, he would also he would be entitled to the selection grade after 8 years.
2/1/19.
That is from 1/6/1992.
2/1/1992.
What the authorities appear to have done is to grant him the benefit after completion of 8 years of service, both as lecturer and as senior lecturer. But counting the same, 5 years after the initial date of joining, that is 2/1/1976. This is sought to be justified by the state by relying upon the amended provision or amended provisions, that is subsections 4-a and 4-b of section 7-C of the Act. A similar question came for consideration before this court in Dr. Ashok Kumar Mahanti Supra, wherein this court
para 10 and 11 years.
Nine do kore. Held as follows: 9, 10, 11 कर दो लोगों. 9, 10, 11 कर दो लोगों.
Again.
No, 9, 10, 11, 12 कर दो. 9, 10, 11, 12. It is stated at the bar that persons appointed through the state selection board have been granted benefit without deducting 5 years of service from the initial dates of appointment. So when did you get the granted date? Granted date is not relevant. It has to be from the approved date.
Yes.
It has to be approved date. So your services was approved from 2/1/1976.
That they have stated in the counter.
সেটা কইছেন তো কাই
Counter question না।
সেটা সেটা সেইটু ক্যালকুলেট করছেন মানে সেটা
সেটা from the beginning I placed that.
কইছেন সেটা কি
2 রে কইছেন counter র।
না সেটা কই নাতি
counter র sorry mal para 5 রে page 2 রে internal page 2 রে about 1 2 3 4 5 6th line from the top. As such, the services have been taken into account with the effect note to 106.
That is the date of approval. So we need not go into that detail. We set it to what? That's not such. The petitioner's case appears to be squarely covered by the decision rendered in Ashok Kumar Mahathi Supra. For the foregoing reasons, therefore, this court finds that the petitioner would be entitled to the what is your prayer?
Selection grade scale.
আমার খালি সিলেকশন গ্রেডটা মাগি আমার আরটা মাগি না
আগে
আরটা মাগি না তো সিলেকশন গ্রেডটা যা হবো কিন্তু আরটা বি চেঞ্জ করে পড়বো না
হ্যাঁ ঠিক চেঞ্জ করে
আমার প্রেয়ারটা কর না you withdraw that prayer
that I forgo that
you forgo that prayer
from 1992 selection.
However, in course of hearing, Sri Das submits that the first part of the first part of the relief, that is
senior scale
grant of senior scale with effect from 1 to 1992. 1 to 1992.
176 plus
84. 1 to 1984 be treated as not pressed.
Yes.
Since since the petitioner had not raised any objection at the relevant time, though stop. However, his entitlement for senior scale from 1 to 1984
to
1984 may be considered for granting him the next career advancement scale. Stop. Para. For the foregoing reasons, therefore, this court finds force in the contentions raised by the petitioner and is therefore inclined to allow the prayer to grant the relief claimed. Stop. Resultantly, the writ application is allowed. The opposite party authorities are directed to grant selection grade scale of pay to the petitioner with effect from 2/1/1992 if there is no other legal impediment. Stop. Since the petitioner has retired from service long since and is said to be ailing, necessary orders in this regard shall be passed by the opposite party number 2 as early as possible, preferably within 2 months from the date of communication of this order. Stop. Requisites for communication of this order. You file requisites.
Yes.
Requisites for communication of order of this order be filed within a week.
Yes.
Whereupon the order shall be communicated to opposite party number 2 and other opposite parties without any further delay. Yeah.
May I try my lord? Now it has been made a opposite partner 1 and 2.
1 and 2. 1 and 2.
Opposite, right.
So if in the meantime this order is set aside or modified, then
Automatic.
I must express my thanks to my brother. Actually, judgment he helped me.
It may be set aside, you never know. I have proceeded on Article 14.
Yes.
That you cannot segregate. That it does not make any, I mean, it simply says aided institution. It does not say management employees or
Selection grade employees.
selection grade employees. যদি তা ହୁଏ ତାହେଲେ ତମେ ସିଲେକ୍ସନ ଗ୍ରେଡ୍ ଏମ୍ପ୍ଲୟିଜ୍ କୁ ଛାଡି ଦଉଛ କେମିତି? ତାଙ୍କର ବି 5 ବର୍ଷ କାଟିବା କଥା। ତାଙ୍କର କାଟିଥିଲେ ଆପଣ କିଛି କହିବାର
ନଥିଲା।
ସେ କେସରେ ଏକ୍ସାକ୍ଟଲି ସେ କେସରେ I think Mr. Jayantarath was arguing he has given a list of people, list of persons who had got it without deduction of 5 years. Anyway,
Item 14.
Can be recollect the last order. 3-7. They are
yes,
Order dated?
3-7.
Additional.
That he will file an addition. You wanted to file an who?
Mr. Mahapatra. But order sheet is different.
अच्छा order sheet भूल ही जाइए। Sir opposite party वाला था petitioner ही जाइए नहीं? अच्छा।
More than the
In order dated 3/7/2023, the word petitioner be corrected as opposite party. है ना? कौन है इसे?
counter टा देले Monday को
counter ना additional affidavit
additional
Vidananda Mahapatra, Learned Counsel appearing for the opposite parties files an additional counter affidavit in the court after serving copy on Learned Counsel for the petitioner who wants some time to go through the same. Is this matter on 16th? 16th. AGA submits that he has received the written instructions. Let a copy thereof be served upon Learned Counsel for the petitioner.
I'll swear the affidavit.
Not necessary. It's upon time like let's this matter next week, my 16th. 16th.
Item number 15.
May I please your lordship, my lord.
Yes.
The similar point before lordship would be Milord.
Notice returned undelivered from Office 7 and 9 with postal report refused. All right. Office note indicates that notice on opposite party numbers 7 and 9 has returned unserved, has returned undelivered with the endorsement refused. As such, notice on opposite party number 7 and 9 is held to be sufficient. Yes. What is this matter?
Milord, OP number 10 is the person contesting and she has been selected for the post of Anganwadi. My humble submission to lordship would be, Milord, the OP number 10, the selected candidate, has practiced deception before the authority by procuring document that when she has not studied class 7 and got a transfer or a certificate and got admitted to the school where she passed out Madhyama, that is equivalent to matriculation certification. Therefore, when the inception is wrong, when she has never studied, when it is borne out from the record from the headmaster of the school concerned where she obtained transfer certificate saying she was never a student, therefore my humble submission or consequential action or result also vitiated. That is this good question for
Good to me.
that the appellate court has
Somebody is appearing for the names do not appear for opposite party number 10. The names do not appear probably. Now is it there? Yes, Professor. बाकी अनुमान को ऊपर रिफ्यूजल है गला कौन है आपका you are one of the candidates.
I'm the second in line. You guys secured 65 and by giving secured 5 marks extra, but extra qualification, she secured 5 marks more than me. So
Yes.
she stood opposite part number 10 stood number 1. I am in the second in the line.
Let us see the improved order. Let us see the improved order.
Yes. Improved order. Improved order as may I invite for kind attention to the improved order.
You file this appeal.
Yes.
You are Rangalata Swami.
Arangalata. But this page 22 would be the last but second paragraph
Yes.
would be better. As dealt with my point that the respondent number 8 has passed HSC examination from Sri Census School and +2. So that was not my point. My point is, she got into admitted into school where she could manage to get the matriculation certificate. So she got into admitted into the school where she appeared matriculation exam by procuring a fake document of transfer certificate of the school where she studied up to class 7. Headmaster of the school concerned said she was never a student in my school where she obtained transfer certificate. So that part has not been taken into.
Where is the appeal memo?
Appeal memo?
Hmm.
Yes. Annexure 6 is as Pet Miller. As page 24.
24.
24, the very ground have taken.
Yes, follow.
That paragraph 2, that the respondent number 8 OP10 is the daughter of such and such and such. Rani Pradhan was never admitted, nor she was reading as student in Netaji UP school. My lord, now I obtained a report from the school headmaster. That is, my lord, at page. May I invite lord's kind attention to the report, annexure 4, my lord. Netaji UP school, where she claimed to have studied up to 7th. Annexure 4:17. Last but 3 line very important. After verification, she was not a student of my school. And also, it also further strengthened the admission register of the school where she got the matriculation certificate, that it has been reflected she came from this school. She came from this school where the headmaster has given report he was not a student.
Got it. Sri B.S. Das, learned counsel for the petitioner is present. None appears. None appears. On behalf of opposite party number 10, despite repeated calls, heard in part, release this matter tomorrow. I got opportunity to Baba. The Ashwin no.
I got a passover. 8 number item passover. Sorry. Item 8 passover.
Password
I beg your pardon that I was not present.
Item number 16.
My lord, this is the matter regarding the engagement of Hon'Ble worker, my lord. Your lordship has earlier had this matter at length.
I am appearing for the opposition of 5 minutes. Lord, here, my lord, I have requested Mr. Mahanti, my friend, my lord, in the morning to take an adjournment. Any day you lost next week, my lord, I pray.
Next week I have got difficulty. Day after tomorrow, my lord, Guruvar.
Day after tomorrow.
My lord. Next week, Rajasthan पड़ेगा बाहर अच्छी पुतला 18 तारीख 18 तारीख नहीं 18 तारीख था
we'll take it up on 23rd.
Your lordship kindly see the last order. Your lordship has passed already. You have taken note of all the submissions of all the parties.
He's requesting for adjournment. We'll take it up. Release this matter on 23rd July. As per 4.
If part are
the opposite party. So opposite में पढ़ो sorry वो कहीं
पाखु थरे खसीगला 23 मसिया रे आसी 24 मसिया आगला पढ़ी पारला नाही आपण 15 दिन समय देथिले तादर असाइनमेंट चेंज है
मोर भूल गेला म कोन करिवे धरण 300 कथा
23 था आगे मुठी सिक कोडे भी सरी जीवा
मिस्टर माते से कथा धरण थोड़ी भूल तो होई छै काई कोर्ट पर लागिले हबो
ना आपण को लागुनी मो लागुची एई पर लोकर दुर्भाग्य आपण असाइनमेंट चेंज हो गेला तापर लिफ्ट आसी
23 तारिख दिन सरी जो डोंट वरी 23 तारिख भीतर किछ होउनी
Appellate.
Item number 17.
Pass over.
Item number 18.
Item 18, my lords. I am appearing for the petitioner. The petitioner was disengaged from my service.
I am for the option number 5, ma'am. Take time, my lords.
The private opposite party, my lords. Notice was sent on the previous occasion.
He has appeared.
Yeah.
Good. Asking for an adjournment.
Take time, my lord. Highly counter.
Counsel for the opposite party, number 5. Seeks time to file counter. Please this matter. August karo.
13th August.
13th August. Counter affidavit, if any, be filed in the meantime.
Item number 19.
Himanshu Mishra बसଥିଲେ ଏଠି pass over.
Item number 20.
In this case, my lord, in the same appeal has been filed for the restoration of RSA 368/17, which was
No. You are moving. You are probably on the weekly list. This is a daily list.
sorry.
Yes. Item कितने?
Item 20.
Item 20. Pass over.
Item 21.
Yes, Mr. Paul.
Ma'am, please. TRPC application.
भाई व्यस्त अछन ना कोन?
No, man.
हाउ? केस टोकाले आपण सुनत?
Man,
कोन विजित रे?
13 under section 13 Hindu Marriage Act.
नोटिस जाइछि के नोटिस के अपियर करछन्ती? Nobody is appeared.
No, man.
देखिए कोन हिच?
2017.
सर बोला?
Other proceedings are pending.
No, notice are neither ready nor undelivered notice written from sole OP and tracking report not been generated. Take another notice. I would notice नहीं जानते तो आप देखिए. There is no information whether notice on the sole opposite party was delivered served or not. Let fresh notice be taken on the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow.
Yes, ma'am.
Peremptorily.
Yes, ma'am. Yes, ma'am.
List this matter on
30th July.
30th July.
Yes, ma'am.
Interim order shall continue.
Item 22.
On the behalf of Mr. Das, my lord, kindly taken this matter next week.
You take fresh notice.
Yes, yes.
Same order कर दो. Same order कर दो. Is there any interim order?
No, my lord.
No interim order. All right. Take notice by tomorrow. We will have to file the requisites.
Item 23.
Same.
Yes, ma'am.
कौन करे ये पुराना मैटर उड़ा से हबो कोटे थारे नोटिस नहीं था फिर करियो. So is there any interim order here?
Yes, ma'am.
If there is an interim order shall continue. देखिए करियो.
Item 24.
Same.
Not placed.
Yes.
Not placed.
Permitted to withdraw but not pressed.
Item 25.
25.
My lordship, on behalf of Mr. Deepak Sundar Rai, my lordship, the notice has been issued to the sole opposite party, but the AD is yet to.
Fresh notice. Take fresh notice.
Obviously.
By speed post, requisites by tomorrow. Is there any interim order?
No, my lordship.
Where is your file? Where is your file? That's your file. Very good. Where is the interim order? Which order?
There is no item.
There is no interim order. Interim order shall continue. File पढ़िनाती, file धरिनाती, court को आश्चर्य सेंति केबे करियोनी. केबे करियोनी आज्ञा. You are a young lawyer. Never do that. I knew that you do not know. That is why I asked you that question. Interim order was passed on 13/4/2017 in this case number 88 of 2017. The proceeding has been stayed. Yes.
Item 26.
26.
26, the delay in filing the second number.
मेरे second appeal no eta weekly list में आ गया. Yes. Pass over.
Item 27.
27.
No instruction, my lord.
So what to do, Mr. Mishra?
Say phone করছি তাকে সে উঠোনি. It's closed.
Will dispose of as no instruction with liberty to
Yes.
approach if any cause of action is
Mine,
developed.
mine.
Same order will.
Mine.
Correct.
Item
No
28.
instruction. No. Item 28. Pass over.
Item 29.
Pass over.
Item number 30.
This matter was heard and this bench has issued notice to the opposite party. But the requisition was filed as lately. That should be accepted.
There is an order 16/1/2024 for acceptance of the already Justice Satpathy has passed that order. Why again it has come?
Sir, no, requisition filed, but
I know. But Justice Satpathy has already passed an order that requisites file late be accepted. ना मतलब आउथर कहीं order pass करे. वो आउथर notice is okay. Each time you are making delay. Mr. Nayak. Requisites filed be
My lord.
accepted and notice be sent as directed. Fixing a short returnable date. Raise this matter on
6th August.
5th August.
Item 31.
29.
Yes,
29.
29 का बोला आपने?
30.
Yes, 29. Take fresh notice. Fresh notice by tomorrow requisites.
My lords.
Is there an interim order?
Interim order is there, my lord.
Interim order shall continue. Yes, item
31.
31.
Yes, my lord. I am appearing for Mr. Subhanshu Thakur, the learned counsel.
Who's for the opposite party?
I am for opposite.
You are the wife.
Yes, my lord.
You are the husband.
The honorable.
What about mediation?
No mediation.
कौन कौन mediation में?
मैंने है ही नहीं एपर्जेंट.
कौन है तू?
Oblige.
What do you say? In course of hearing, it is stated at the bar that the dispute between the parties can be attempted to be resolved amicably through the process of mediation.
Oblige.
Accordingly, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear pursuant to notice issued by received from the mediator and to render full cooperation in the mediation process. Let's this matter, August Master.
20th August.
20th August, interim order shall continue till the next date.
My lord, meanwhile, the case has been posted to 19th July in the.
Stay, interim order to continue kala apne investigation.
Obliged.
Item 32.
You will have to produce a copy of this order before the court. Item 32. All right, pass over.
Item 33.
बहुत pass over रहेगा जी. Pass over.
Item 34.
Item 33, lordship, kindly pass over.
All right, pass over.
Item 35.
Sanction पड़ी Sanction sorry हो sanction पड़ी.
My lord, in this matter,
Yes.
in this matter, article virtual. My lord, the matter is listed for hearing on my regular bail. My lord, in this matter, I have suffered 3 years of incarceration. I was on interim bail for a period of 4 months, and after that, I have surrendered on time. And there is no allegation against me that I have breached any terms or condition imposed by this honorable court or the trial court. No case of any nature has been fixed against me during the phase of interim bail. And my lord, although I am from Andhra, Telangana, but despite the fact I have surrendered on time, and I appeared on each and every date in the trial court, but no evidence has started, and out of 16, only 1 witness has been examined, lordship. And I have annexed certain judgments in my bail application. If my lord permits, I would like to apprise what the Honorable Supreme Court has told.
What judgment, Mr. Manohar?
Lordship,
ये judgment में क्या होगा सर?
My lord, it's in the page number 39.
क्या होगा सर? वो judgment देख के क्या होगा?
सर बेल आप दे
बेल का है, बेल दे देंगे नहीं देंगे, इसमें जजमेंट क्या है, क्या इसमें लॉ क्या दिखाएंगे अब हमको?
नहीं सर हमारी क्या है औकात की, मैं आपको सर
अरे औकात आपकी है, औकात और किसकी है?
नहीं सर My lordship, वो अकेला बेटा है, and he is the sole son of his mother, and during the
इसलिए गांजे का धंधा कर रहा था.
No, my lordship, if we see the documents, actually he is the owner. और जो उसका दोस्त था
3 years no trial.
550 kg.
No, 3 years no trial.
No trial.
That is there, so that's why your lordship released him on interim bail once. But from the exclusive and conscious position of the petition,
but he has
also is the owner of the vehicle.
No, that is true.
That vehicle.
I'm not saying anything on merit, but the fact remains that he has not misused his liberty and he has appeared, he has abided, he has followed, complied with the conditions imposed by this court. So that shows his conduct.
The lordship may test one more time. He may be given chance.
और एक बार जाइए.
लॉर्डशिप इंटरिम बेल ऑनरेबल सुप्रीम कोर्ट ने
आप क्यों ऑनरेबल सुप्रीम कोर्ट के बारे में बोल रहे हैं? नहीं तो फिर रिजेक्ट कर देते हैं. आप जाइए सुप्रीम कोर्ट से बेल लाइए.
नहीं सर आप ही दीजिए सर. मिसफॉर्चून होगा मेरा कि अगर आप बिल नहीं देंगे.
Okay, yeah. This is a Supreme Court has directed to hear the bail application expeditiously.
Yes.
Yes.
We consider the bail application
Yes.
because this is a matter, you see, and he has a point. Well, this is a case of the year 2021. He has been in custody and you don't conduct the trial at all. Trial has not begun. We had called for a report, I believe.
Yes, my lord.
Yes, Mr. Manohar, we had called for a report from the
Yes,
court
my lord.
below. Submission
Yes,
of report.
And out of 16, only one witnesses has been examined till today. Lordship, जब मैं interim में था, मैं हर date को appear हुआ. I appeared on each and every date, but no witness has been examined. And even after that, I have surrendered on time.
Call once more a report.
No, it's a report is there. 12-6 ro.
12-6.
Masse nahi niche report ro.
Lao gote ହେଇଥିବ କି ଦିଟା ହେଇଥିବ? Maximum ଗୋଟେ କି ଦିଟା examine ହେଇଥିବ?
We'll grant him bail. We'll grant him bail.
Yes, my lord. Please, my lord.
With my objection.
Oh, certainly.
Yes, my lord. And stringent condition, my lord. He will surrender all his address and mobile number for everything.
No, he'll appear
regularly. Yes, ma'am.
The petitioner is in custody since 22nd February 2021 in connection with such and such case. It is alleged that the petitioner was transporting contraband ganja weighing 550 kgs, 400 grams in a truck, or what is it?
In a Bolero pickup.
In a Bolero
pickup.
In a Bolero pickup vehicle when he was apprehended by the police officials. So, his earlier application for bail, being BLAPL number 9044 of 2022, was rejected, having regard to the taking note of the fact that the contraband was primarily found to be in his conscious possession. Stop. Subsequently, on the ground of delay in commencement of trial, the petitioner was granted interim bail. Wow. See, where is that order?
My lord, it's in the page number. I have filed the IA. It is in that IA, lordship. By the
order dated 7/12/2023, passed in BLAPL number 10834 of 2023. He was granted interim bail.
Yes.
Interim bail for a period of 3 months. By order dated so and so in such and such case. The petitioner surrendered to custody in time, and there is no allegation of misuse of liberty by him. Further, he appeared before the trial court on each date of posting of the case without seeking representation. Stop. The present application, in the present application, prayer for bail has been renewed again on the ground of delay in conclusion of the trial. Stop. Sri Shyam Manohar, learned counsel of the petitioner, would submit that only 1 out of 14 witnesses have been examined so far, as per report submitted by the trial court. The petitioner has been in custody for more than 3 years. Sri Manohar further refers to some judgments passed by the Supreme Court in respect of persons who, in respect of similarly situated persons, where bail was granted, taking note of inordinate delay in conclusion of trial. Sri Sashikanta Mishra, learned counsel for the. You are also Mishra, I believe, Mr. Manohar?
Yes, my lord.
Why are you hiding it? Everybody is Mishra here. The Sri Sashikanta Mishra Learned State Council has opposed the prayer for bail by submitting that huge quantity of contraband was seized from the exclusive and conscious possession of the petitioner, and therefore he should not be granted any liberty. Stop. He, however, fairly submits that there is no proof of any misuse of liberty by the petitioner while he was on interim bail. Stop. Taking into consideration the allegations and the submissions made, as also the fact that the petitioner has spent more than 3 years in custody, and there is and the trial is progressing at a slow pace. This court is persuaded to hold that this delay amounts to violation of the fundamental right of the petitioner to speedy trial. Under such circumstances, as also looking at the previous conduct of the petitioner referred above, I am inclined to take a lenient view. Let the petitioner be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. 1. He shall furnish his contact address and telephone number to the IO as well as the court below. Next, he shall personally appear before the trial court on each date of posting of the case without seeking representation through lawyer, and in case of even a single default, NBW shall be issued by the court to take him into custody again. That's all. Yes, that's all.
Yes, my lord, I am obliged.
Item 36.
None appears. Shut up. Pass over.
Item 37.
37, may please. Disposed of, I have filed an IEA. The modification, my lords, kindly have a glance to page 13, my lords, of my IEA, Annexure 3.
Yes.
A bail appeal had appeared once again before your lordship. The bail lordship is disposed of. On second line, my lords, learned counsel for the petitioner seeks permission to withdraw the bail appeal with a liberty to file appropriate application in the disposed of bail application. That's why I filed, my lords. In the meantime, the main accused has been released on bail by this honorable court. My lords, carry may be granted. Page 11, my lords. Hence, it is directed that the petitioner be released on bail in the aforesaid case.
Prayer for modification is allowed. The following be added at the end of paragraph 5. Further, the court below shall maintain parity.
Yes, that's next. Surrender time to extend.
Separate 2 weeks for the time is allowed.
Publish.
Item 38.
This case is also having custody since 28/3/2020.
Yes, Mr. Jana.
Custody since 28/3/2020.
This is SCST?
Juvenile lords.
No, juvenile, okay.
And there is 2 sets of trial lordship. So far this juvenile is separate trial, and so far the other adult accused they are separate.
Why has this case suffered so many adjournments? What has happened?
The last order.
Since trial is in progress, you will produce the depositions of some more witnesses.
Examined in the meantime.
Actual submission that this case is now conducting by the State Defense Council before the Lord of Court below. I am unable to collect the deposition copy. Lordship can be through court order, then it can be possible also.
This case is concerned.
Sri Jana, learned counsel to the appellant submits that the trial is being conducted by a court appointed by the court appointed state defense counsel. And therefore, he is unable to obtain the copies of depositions. The court will be directed to transmit the soft copies, transmit the copies of the depositions of all the witnesses examined in the case through email.
And after report, because also I am custody. Out of
The court below shall also submit a report regarding status of the trial. This order be communicated to the court below forthwith. List this matter as you are now 23rd. 23rd. ଆଜ୍ଞା ବହୁତ ପାସ ହେଇଛି ସମସ୍ତେ ୱେଟ୍ କରିଛନ୍ତି କି ଆପଣ ୱେଟ୍ କରିବେନି ୱେଟ୍ କରିବେ ସର ଆଉ କଣ item 39 yes
This is the third journey of the petitioner Millards. It's also the depositions copies I have filed today, which if that may be called for, it can be heard. There are 4 witnesses which have been examined.
This is a case of murder.
Yes,
Yes.
And I have filed the copies of the depositions today and also served a copy in the office of the advocate. If they can be called for Friday, if your lordship will take it.
No, earlier it was rejected.
Yes, my lord. This is the third journey.
Where is the rejection order?
No, earlier it was rejected twice. I have given it in reference, my lord. BLFL 3073 and 12695 of 2022.
So when shall we take it up?
My lords, I have already filed. If your lordship can call that because they must be scanned and on Friday, my lords.
Shri Pandal and counsel for the petitioner submits that he has filed copies of the depositions of the witnesses in the counter.
Yes, my lord. And as well served that.
And also served the same on the and also submitted the same in the office of the Advocate General. List this matter next week. The copies of the depositions filed in the court, filed in the counter, be tagged to the case record. Yes.
Item not grateful, my lords.
Item 40.
Your lordship kindly see the previous order your lordship passed in another bail application, page 15, paragraph 4. This petition did the court.
Not to alias Abhishek Rautray.
My lord.
Do you stand on the same footing?
My lord, same footing. Paragraph 4.
Yes, my lord. They have taken a vehicle on hire and say disturbance thila se fare ko nei ki segala 1 tanga dabo. So they strangulated the only confessional statement and 27 maybe statement record is. Last order, your lordship says they have annexed the co-accused bail order.
1, 2.
So yes, similar, my lord.
Same order.
3 persons were there.
Yes, same order.
Item 41.
The lordship offense under section 370 and 370A, 35 and 6 of prevention of immoral trafficking, your lordship. Petitioner is custody, your lordship, 16/4/2024, your lordship. In this case, your lordship, co-accused or personally released on bail or similar putting, your lordship. No.
Who are you? Who are you? You are Swaraj Vishoi. What is the role of this Swaraj Vishoi? The person who was released on Prasad Kumar City is one of the hotel. That is, because his name was not there in the FIR.
No name in the FIR, not in the.
Not the statement of the victim. But what about your case?
Your lordship,
What about your case?
co-accused person as.
No, what has happened to does your name find place in the FIR?
Statement of the another.
No, is your name there in the FIR?
No.
FIR
Custody.
FIR copy देना. The lordship see the rejection order, page 10.
FIR copy देना थी 161 देना थी किन को after the case we will see.
Yes.
161 statement. 161 statement.
क्या रखी थी कौन पे FIR कहीं କିଛି ତ ରହିବନି ସବୁ ରଖିବେ ଆପଣଙ୍କ ପାଖରେ ଆଉ ଆମେ ଦେଖିବୁ କଣ Next, let the state council go through it. We'll take it up tomorrow.
Yes.
Let copies of the FIR and statement of the victim under 161 be served upon the state council in course of the day. Let this matter tomorrow.
Item 42. May I please, your lordship. First, under section 20B2C of the NDPS at your lordship. And in this case, 5 accused persons are there, your lordship. And out of 5 accused persons, 2 were granted bail by your lordship. The petitioner is inside custody since 24/9/2021, your lordship. Facts of the case is the informant got information about transportation of ganja in a 4-wheeler vehicles, immediately rushed to the spot and detained the vehicles. And inside the vehicles, he found 3 persons, your lordship.
The one Pan Bhue
My lord.
has been granted bail because he was implicated on the statement of co-accused.
He is not on similar footing.
This
present is
present at the
petitioner is
vehicle.
inside the car, 3 persons were there. Out of 3 persons, the present petitioner is one person, your lordship. Yes.
And from the vehicles,
What is the quantity? 296 kg, 750
My
gram.
lord.
The trial is going on out of 29, 12 witness here deposition has.
My lord, I
filed.
have served the deposition. Out of 29 witnesses, 12 witnesses has been examined. Some are supporting, some are not supporting the case, your lordship. On the ground of delay in trial, I am seeking bail, your lordship, relying on the judgment of your lordship, recent judgment. Here the petitioner is more than 2 years, 10 months in custody in that case. Maximum 2 years in custody, your lordship. This everything. Yes.
Almost 3 years, your lordship. But he was not situated similarly like other office person released on.
2.5 years
Very
ago.
much present in the vehicle.
2.5 years ago. The petitioner is in custody since 24/9 to not regular bail. One. Interim.
Regularly, the persons, 2 persons who were religion, but regularly they were attending.
They may appear. How? What is the guarantee that he will not?
Local man, there is no antecedent, your lordship. Local person of 22 years boy, your lordship. Kindly consider. 22 years boy and local person, your lordship. No antecedent, your lordship. That may be considered, your
The
lordship.
petitioner is in custody since 24/9/2021 in connection with such and such case. It is alleged that 4 persons, including the petitioner, were transporting contraband ganja.
3 persons.
3 persons, 3 persons, including the petitioner, were transporting contraband ganja in a vehicle. Contraband ganja in a vehicle weighing contraband ganja weighing kete
296 kg, 750 gram.
296 kg, 750 grams in a vehicle when they were apprehended by police. It is submitted that
Two accused persons were religion.
Two co-accused persons have been released on bail. It's further submitted that trial is proceeding at a slow pace with only 12
examination.
with 12 out of
29
witnesses being examined so far. It is further submitted that the petitioner is a local man and has no criminal antecedents. The United State Council has opposed to pray for bail by submitting that the petitioner does not stand on the same footing as the co-accused persons who have been released on bail. Further, the contraband was seized from his exclusive possession.
Yes.
Taking into consideration all the above facts, and in particular the fact that that the trial is progressing slowly, this court is of the view that same amounts to violation of the principles, same amounts to violation of the rights guaranteed under Article 21 of the Constitution, as the petitioner has been in custody for more than 2.5 years. So, under these circumstances, I am inclined to allow the prayer for bail. Let the petition be released. Each day appearance.
Item 43.
May I please, Your Lordship? Reason for again approaching this honorable court for bail, my lord. The petition is in the custody since year 2021, my lord, for offences under section 364, 302, 201, 34, my lord. And the on some witnesses have been examined, my lord, and cross-examined. None of them stated a single word about the commission of offence by the present petitioners, my lord. And
What is the name of the petitioner?
Madam?
What is the name of the petitioner?
Name of the petitioner, my lord, Sudarshan Sethi and Jagdish Sethi.
Yes.
The father son do. And they allegation against that they have kidnapped this person who have killed and caused him death. My lord, but none of the witnesses has been examined, my lord. They stated a single word. Your lordship was the last few occasions, 2 occasions have granted interim bail to them, the accused persons, my lord. And now approaching, my lord, the last 3 years they have been in the custody, my lord. They and we are ready to cooperate with the investigation, my lord. And none of the witnesses utter a single word, my lord. As per with regard to the commission of offence by the present petitioners, my lord.
Your Lordship, say PW 1, 2, and 16.
Well,
PW 1, page 64.
is the metro, my lord.
Because I had not seen the incident of murder of my uncle, but I have seen when the accused persons kidnapped my uncle.
Yes. PW 2, Your Lordship.
I saw both the accused persons brought the deceased in auto rickshaw and stopped the auto rickshaw near a canal. Accused Jagili alias Jagili. Accused Sudarshan dragged the deceased from the auto rickshaw. How many? No.
PW
Now I remember why I rejected it. I remember.
seen that.
My lord, may
That's why Your Lordship granted interim bail.
he has seen that they are traveling in the same order. Under the influence of alcohol, he may have fallen on the canal and died, my lord. But
Take that plea during trial.
my lord.
Take that plea during trial. How many?
Bag entry achi 25 witness examination.
And maybe one other 2 witnesses also examined in between the pendings of the bail application.
No,
If
sorry.
possible, I will file the deposition copies.
You file it?
My lord. Kindly.
Counsel for the petitioner seeks permission, seeks time to produce the depositions of some more witnesses examined in the meantime. Let's this matter on 30th July.
Item 44. Paper extension of time.
First time it has come?
Yes, ma'am.
2 weeks time.
Problem.
Dakila pala हमको जाएंगे ऐसे कोर्ट में टीम हाँ ये रखिए
Item 45.
May I please use that 20B2C and 29 of NDPS, sir.
Yes.
Your Lordship, on that spot that police has arrested one Gopal Pal. Gopal Pal.
Hmm.
Who was standing near contraband contraband that person is standing that. And when police could declare that person as
what is your name?
Rathi Baroi. Rathi Baroi. He has stated he might. Sorry,
Yes. Your name in the affair.
Name in the affair, but I have absconded. Your Lordship on page 11.
Yes.
On page 11. Upon interrogation, he informed that Pratham Patra is a regular dealer, financier, transporter, and contraband ganja, and has been engaged in the illegal trade since long time. He usually procures this illegal contraband article from Kalimala PS area near Gurulur, Kamalapadar, and Kurampur, and popular area. His associate name Rathi Baroi. Rathi Baroi, 2 Munna Biswas, and 3 Naresh, 4 Nitai. And
So this is a co-accused statement.
Co-accused statement and ABLAPL 13980. that your lordship rendered judgment that while in custody, anticipatory bail, that judgment your lordship had allowed that bail application. Similar footing, man.
Yes, yours.
The
You are not
petitioner
rendered that.
appearance arrest in connection with such and such case. The prosecution case is that one Gopal Pal was apprehended by Malkangiri police when
Lordship, that
he-
Kalimela police.
by Kalimela police. Hala. When he was present near several plastic bags which contained ganja. On interrogation, he gave out the name of his associates, including the name of the petitioner. Stop. On such basis, the petitioner has been implicated in the case. Stop. Apart from the statement of the co-accused, there is no other evidence to show the presence of the petitioner at the spot or of his possessing the contraband. Under such circumstances, I am inclined to take a lenient view. However, instead of no, I am inclined to take a lenient view. Under such circumstances, while not being inclined to grant anticipatory bail, for them to surrender and release each decade.
In fact, the director has recently joined. He has instructed to find out that file.
Item 9, who's appearing for the other side?
I will intimate you. Mr. Authorized Associate, he later on got the information that this has been the order from me. So I will be informing him. Any next date, your lordship fixes, I will inform you.
Next week?
Next week, your lordship have fixed it to 12. May I pray, they have prayed for 15 days in that last instruction. Your lordship may call it on 26th.
26th will be too late. No.
On
22nd. 3, item 9. Huh? Shri Das Leonard AG submits that he has received a letter from the assistant director that the original file in question could not be traced out, and therefore 2 weeks further time is required. Shri Das therefore requests that the matter be adjourned. Release this matter on 23rd July. It is made clear that no further adjournment shall be granted. Let him appear on that day.
In case it is not produced on that.
The Director Higher Education shall appear in person before this court if the file is not produced.
It's not that. So item number 7.
May I please? It is my third round journey on Lordship. With the informed order Lordship glance page 51, annex 18 Lordship. The matter is related to ASA appointment engagement of ASA.
The annexer कितने कोई ले?
Annex 8 page 51.
Annexer टा कितने गए पुणे थे?
8 Lordship. Page 51. The matter was remanded to the authority Lordship, and authority duly considered them, stated that since on the day of scrutinize of the document, I am unable to fix my original document, and accordingly I am limited.
So, what is wrong in it?
I am coming Lordship. You see the advertisement annex 1 page 22. So as per this advertisement, I will see myself and so far the private opposition others made application for the engagement ASA. And on the application, I have been due to my mother's death, I couldn't able to file my original certificate regarding the my matriculation pass mark sheet. And on 17th, we have been called upon by others also to appear before the authority for checklist of the original mark sheet. On 17th, since I could not produce, on 18th, I filed an application before the authority that yes, I have been got the said application original mark sheet. I would like to produce the same. Maybe consider. They have not been considered. Then also, as per the annexer 12, annexer 1, page 12 also, 7 days time has been there to file, punish the final merit list before the authority concerns. So they have not been within 7 days, they have submitted the same before the authority also. On 17th, there is a check. On 18th, I filed an application. They give me, I have already got my original application. I would file the same. They have not been taken the same one. On 28th, lordship, they submitted the final merit list before the authority. Although I secured highest mark, I secured highest mark. You also grant the provisional mark. They have been.
You may secure the highest mark, but unless you are eligible, if you do not satisfy the eligibility criteria, that is of proving that you have passed class 10 by producing the original certificate.
No, with Xerox certificate file original was not with me by.
Original duplicate
No, duplicate was produced lordship.
Yes.
Duplicate certificate so far Xerox
Take instruction.
compending.
Take instruction.
And notice is required to be issued for a private opposite party if it is necessary.
Alright. Sri S.N. Patnaik, Leonard AG accepts notice on behalf of opposite parties. 1 to 8.
No, 1, 4, 5 and 6.
1, 4, 5 and 6.
Yes.
I think somebody is appearing for NHRM. Yes. They have Mr. Bibhu Tripathi. Let 1, 2, let कितने बाकी है?
1, 2, 3, 4.
4 extra copies of the writ application be served upon Sri Bibhu Prasad Tripathi, who usually appears for the National Health Mission within 3 days.
Register for opinion number 9.
Bracket opposite party numbers. Issue notice to the opposite party number 9 by registered post with ID. Returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter. 13th August. What I notice as above.
Any
Yes. Continue.
subject to result.
Opposite party number 8 is continue.
Good. Any outcome of subject is interpretation in the
That goes without saying.
2019. That goes.
So that goes without saying. So once notice is issued means automatically. Yes.
So write note 8.
That please let me learn once. Snehalata Mahanti, after working 2 decades in service as an Anganwadi worker, she expired on a sudden, leaving behind her permanent disabled husband and the present petitioner's daughter-in-law. My humble submission, I made a representation to the opposite party number 213, and they may transmit to opinion number 1 to bring about the scheme for a compensatory appointment. That is my question. Even though Anganwadi worker when undertaking arduous tasks, the experience.
If law does not permit, I will never allow this.
Only opinion number 1 may take a benevolent.
No. You may withdraw and file a.
My representation 1 and 2 maybe.
No. I will not issue any direction, which is dehouse the rules. There is no provision for any appointment for Anganwadi worker compassionate appointment.
Nice, but the opinion number 1.
CBS Das Learned Counsel for the petitioner seeks permission to withdraw the
there is a
writ application. Amar nahi kon kari. Ame to Odisha loko ame kahi Kerala ko follow kari amku jibuji parni.
for the state government may.
It may be God's own country, but here this is a state. It is known for what? India's best kept secret. You will know about Odisha if you come to Odisha. So we are proud of our heritage. Everything is there. Why should we look at others?
The petition may move to the opinion number 1.
Sir, how many? Sri Vedas Learned Counsel with the petitioner seeks permission to withdraw the writ application with liberty to move the authorities by submitting representations.
Opinion number 1.
The appropriate authorities. The permission is granted with liberty as aforesaid.
So write number 10.
None appears on repeated calls. Let this matter. Part matter. Okay, 23rd July. Yes.
So item number 17.
23rd July.
July. 17.
Please, my lord, last occasion, my lord has heard the matter at length and directed to my lord and senior to verify the affidavit which I had given that I am continuing till 2017. I have challenged the order by annexure 1.
You filed an affidavit on 12/12/2012.
That has to be.
What have you said there? What have you said therein?
Yes, I am stating therein that though they have alleged that I have not working since 2015 and staying at Chennai, but document shows that I am working till
Yes,
9
it does.
2017.
What is your reply to the affidavit?
That in fact, I have not filed a reply affidavit.
You need not. You need not. What is your reply to the amendments made in the affidavit?
That instruction I have sought, but I have not got it.
What this is? This was passed on 25th of June.
Yes.
United State Council requests for some time to comply with the previous order. Lists this matter on 30th July. The order will be complied with positively.
Okay.
So item number 19.
May I please? So the petitioner is a GRS employee. GRS, Gram Rozgar Sevak.
What will be the counter?
Counter is there, virtually there is nothing.
Counter has been filed.
Here the issue is that, my lord,
Yes.
as per the rule, your lordship can see the page 20, page 10, paragraph 20. After not enacting the law that data entry operator method of recruitment condition service rules 2024. In that rule 4 stipulates regarding method of recruitment, not less than 70% of the cadre strength shall be filled up by way of direct recruitment. 30% from the existing employees. Commissioner does not, and 30% of the cadre strength shall be filled up by means of a selection of eligible GRS engaged MGRS scheme. It is humbly submitted the petitioner comes under 2 of the efforts of 2014 rules. But here the Lord, they created a confusion by to avail that benefit, that rule 10(5)(b) in paragraph 21 I have stated. It says about the vigilance and criminal clearance report. To this, the reply your lordship can see in the counter.
No, some interim order was passed.
Yes, the interim order passed.
What was the interim order?
Interim order, no, any promotion given will be subject to the result of the application. But the point is that if they have given promotion as per the rules throughout the state, excepting the district of Bargarh and Balagi. So here, since the counter is already filed, I say your lordship may direct to consider the case of the petitioner, because I'm only the mechanically here, your lordship can see for a moment before passing the order. And
So you are referring to the counter. You are referring to the
annexure reply to paragraph 21.
Paragraph 21. I think in paragraph 6 and 7.
No comment.
No comment to offer.
It's a vital point. That is the thing. The whole point is that.
So let me just understand. So the rule permits the Gram Rozgar Sevak
should be considered 30%.
30%. 30%.
And one time, my lord. That is the first one time that will be considered only.
All right. So what is the problem here?
Here they are not going to consider me, Lord, as I have given to understand, and they have not denied that. That because a criminal case is pending against me, pending. Here, how that case is pending? Your lordship kindly see is a mechanical case instituted against me, for which now I am proposing to file quashing application to quash that cognizance. Here, your lordship kindly see for a moment annexure 5. Page 22, madam.
Yes. Page 22 is annexure 4.
Annexure 4. Annexure 5 is page 23.
Yes. In course of my visit to Budarpalli Gram Panchayat.
Yes.
I select block and I visited cash book.
I verified the cash book of Sashikanta. You'll also know that GRS is the lowest employee. Neither he is in custody of any documents, registry or anything, nothing. All financial and everything has been dealt with by the Sarpanch with the executive officer. Here in this case, what happened? The Sarpanch and executive officer, without my consent, without my knowledge, behind my back, they deposited certain amount in my account, for which I am not responsible. And being the lowest paid employee, they said that you, as and when they said that you withdraw and pay for a construction work. You'll also know his, precarious condition that he has to withdraw and give it. So he has got nothing to do. Here, neither he was allotted that work, nor he, doing that work, nothing. But the amount deposited by Sarpanch and this thing, they said that you withdraw and give it to him. I was doing that thing. So there is no offense made out against me. So here, because of the huge corruption by the Sarpanch and some other incident, well, my mother complained to the Lokpal, Lokayukta. Inquiry was made. I was not noticed. Directed the vigilance to make an inquiry. The vigilance, what he said, because I have received money from the person, those who have without my consent, without my knowledge, he has also given my name. And receiving that report, Honorable Lokayukta directed to file the charge sheet, and charge sheet has been filed. And now the cognizance has been taken. Accepting that there is nothing, and your lordship's judgment, I think, must in that last year only, that even if the case is pending, he cannot be debarred from promotion. Then I have stated in.
No, there is a provision for sealed cover also in such cases.
Sealed cover, and further your lordship is directed by going further, a judgment of this honorable court, I think it is passed by your lordship. WPC 20342 of 2021, decided on 8/9/23, referring to various judgments, including that sealed cover 91 Supreme Court. So they can be considered. Because now I am not yet found guilty. And here in this report, they say that there is absolutely nothing.
The only thing that
no proceeding has been initiated by the collector, accepting the Sarpanch.
And the only thing that the rule stands in your way is that there has to be a vigilance clearance report.
But that is also vague. Clearance means what? If suppose I am convicted, they should have said by that I am convicted. But to that they reply is nothing. Whether this will be a bar or not, they have.
What does Janaki Raman say?
That is with respect to promotion, man.
Promotion. This is also promotion.
This is by way of selection.
No. Way of selection. Maybe, but the same principles will not apply.
But there is a process of selection.
There is a process of selection. In the case of vigilance report, if I think promotion can be considered.
In the case of promotion, my lord, it has to be considered, but the recommendation has to be kept in a seal.
It has to be kept in a seal. So non-consideration cannot be accepted because in that case, Janaki Raman, the court made a distinction between that when can a proceeding be said to be pending? Only after submission of charge sheet. And here, as Mr. Mishra says, cognizance has also been taken. So the criminal proceeding is pending. So there's no, I don't think there's any bar.
No.
Is there any bar? That's what I'm asking you.
My submission, madam.
This is a direct report.
There is a statutory provision.
Yes.
And that statutory provision empowers, my lord, the authority to fill up the post by two methods. One is by direct recruitment, another is by selection.
Selection.
By selection.
No. Promotion.
Let us see the rule.
Promotion.
It is at page number 9. My counter, my lord, it is at page number 9, annexed by 1. Rule 4, my lord. Method of
30% from the GRS. If somebody has worked more than 5 years. So if anybody comes, is automatically promoted.
Even otherwise, even if accepting for a moment that it is not a promotion, as you say, and I'm willing to accept it also.
Yes.
Will the same principle not apply? Because you also says vigilance clearance.
Yes, ma'am.
Sir, which judgment are you referring to?
That is, I could not get the printout somehow.
Permitted, my lord.
Yes. This is WPC 20342 of 2021, decided on 8/9/2023.
Yes.
Page number 11, Rule 10.
Rule 10.
There is a procedure for filling of the vacancies by way of selection. One is by way of direct recruitment, another is by way of selection.
That is what selection, 5-year service.
But as a one-time measure, by way of relaxing the provisions of these rules, those GRS who have completed 5 years shall be absorbed.
Yes. That is to appear through recruitment to the commission.
Yes, and one of the conditions is that vigilance and criminal clearance report.
That the ACRs of the different portions are to be assessed by a DPC, and there will be recommendation only on the basis of the ACRs. Here there will be recruitment.
All right.
Wherein the candidates of the different.
Even accepting it, but you come to that clause 5B, vigilance and criminal clearance report. What does it mean? What does it mean?
It is only to ensure that a particular person is eligible for.
That he has not been convicted.
Yes.
The pendency of a case cannot be.
Well, I am saying if I am eligible, I should be considered. I have completed more than 5 years.
I don't dispute that, my lord. Right of consideration cannot be denied to a particular person.
So that is what he is asking.
I am also making a submission to that effect. But taking into consideration the relevant provisions of the rule.
Obviously, the rule cannot be ignored.
Most of it.
What are you saying?
That is what I said. They should consider. But the whole point is, if I have completed 5 years and I have not been found guilty, I should be promoted. I should be direct. Mandamus cannot be issued. Mandamus cannot be. If I have 5 years I have completed, I will be considered. And if I consideration, if I come selected, then they should.
No, your submissions can be taken note of to the effect that there may be a criminal case, but you have not been held guilty therein.
That is the judgment. You will also can see 20342.
नहीं तर प्रिंट आउट नहीं
ना आनी पहले मुझे
कितने जो बार करो WPC number. This is my judgment.
Probably 20342 of 2021. Oh, sorry, Justice Sashikanta Mishra. 20342 of 2021. Decided on 8/9/2023.
Last.
If your lordship will see from this.
I'm seeing it. This is a departmental proceeding and promotion.
Yes. This is also from the cadre. They will
pass a detailed judgment here.
Yes, ma'am.
I'll pass a detailed judgment.
This is also from the department process 30% from the cadre.
No, Mr. Mishra, I think I'll pass a judgment. But I'm making it very clear. I cannot issue a mandamus directing them to promote you.
No. If I'm selected,
consideration will be there.
They will consider my case.
All right.
Because I'm not found guilty in view of this judgment also. If I should be considered. If I'm considered, then automatically I will be.
That is up. This promotion will always be subject to the result of the.
Yes,
what is
exactly. This judgment
that your submission.
This judgment is that this.
There the
21 judgment.
concept of promotion was there.
No, I'm not on promotion. I understand your point. But here also.
And my lord, there one executive instruction is there. That is of 18/2/1994, guiding the principle of silkover procedure, which has been amended from time to time. That has been interpreted where there is also a scope, my lord, that in case the proceeding is not concluded within a certain period, then what will be the consequence? The ad hoc promotion can also be granted. But here in this case, there is a statutory rule.
It says in order to be eligible for selection, the selection board constitutional rule 11 for the purpose shall consider satisfactory performance color, vigilance and criminal clearance report. In his case, he has not been held guilty. So what would be the effect of it?
My lord, that the authorities will take a decision fast, my lord. In that case, my lord, it is premature. Let the authority have to take.
Let them consider that. Let them consider.
I have said that they are not going to consider. He has not denied that.
No, I will direct them to consider.
21.
I will direct them to consider. Judgment is ethically, without entering into any controversy, that we simply pass one paragraph order, which will, I think, suffice. And supposing he is not considered, then he can come to the court again, challenging a particular order.
If I am eligible, they will consider. If I have completed 5 years of service, I come under the zone of consideration for appointment in the 30% fill up.
No, but sir, subject to other eligibility also, as provided under Rule 5.
The other is all right, but so far I am aggrieved only because of the vigilance and criminal clearance. What is that? What clearance? Is it vigilance or clearance? What type of clearance? Who will give? I mean, completely vague. They should, with that vagueness, they have not explained it in the.
I remember now. I had also asked you that you should have challenged the rules also.
That is a Herculean task, but the whole point is that that is not given. So there is no bar in the rule that if a case is pending, he will not be given. There is no statutory clear rule. A case is pending, he cannot be.
I'll look into it, I'll pass order.
They are all, they have not, they should have explained that thing I mean, 21, that this rule indicates this, or it will mean this.
Okay. I will pass order today. Okay.
So the whole point is that
it will not be judgment, it will be a order of today.
My lord, clearance of vigilance and criminal, তার মানে কোন? Does it mean whether তার FIR হয়েছে, কি found guilty হয়েছে, তো কি appeal, তবে clearance who will give? Clearance for the vigilance department দেবো, না তার মানে police, DG police দেবো, না কোন দেবো? This is, I mean, and in that case, they should not debar me from consideration.
Yes.
If I am otherwise eligible.
Okay.
Because there is a case pending against me.
All right. Next bit.
And in that report also, they found the Sarpanch and the executive officer. They have not initiated a proceeding against me. They have not suspended me.
All right.
Nothing.
All right. Yes.
So item 20.
Item 20. No, it auto is only. I
20 টা next week is.
Next week is paid for. No, you take fresh notice.
Yes, sir.
See, you notice what I'm going to fresh notice by speed post, requisites by tomorrow, a date will be fixed.
Day after tomorrow.
No, tomorrow, somewhere to go, day after tomorrow. Yes. Interim order to go.
So item 26.
26. None appears on repeated calls. List this matter 1 week after.
So item 28.
Interim order stands vacated. Yes. Item?
Item 28.
Item 28. None appears on repeated calls. List this matter 1 week after. Item.
Item 32.
Mr. Is it your matter? Sujana Mr. Lekhai?
I'm sorry.
33. Itte kotha mon roche amar. Yes.
So item 32.
32.
Item 25.
Item 25 कौन है जी?
30th July.
Somebody had made a mention 30th July. Press notice में 30th July. Yes. Item
32.
32. None appears on repeated calls. 1 week after.
Item 33.
Item 33, the lordship and lordship can see order dated.
The order dated 30/4/2024 be corrected accordingly. Yes, Mr. Bhandadev, what is this?
Your lordship kindly say order dated 14/5/2024.
14/5/2024. 14/5
for settlement, my lord.
14/5 too?
Yes, my lord.
That he would pay to maintenance, whereas the
For settlement of the matter, my lord. I'm ready with.
He's trying to pay the amount towards maintenance. He requests for some time for the purpose. Yes.
And subsequent 17/5, your lordship, I have taken time. And I am ready with a draft of 35,000 and for 15,000 already I have paid to my lord Paytm, my lord, through the account of the my lord of the my lord.
So take that. You take that draft.
Yes,
so we can send it to mediation then.
Yes, my lord.
That's the Mr. Pradhan. That was the, I think this is
the intention. Your lordship.
They do nothing.
Yes, my lord. And the 15,000 I have also maintained a slip.
SK Bhandadev furnishes original demand draft for rupees
35,000.
For 35,000.
And 15,000 already.
Which is accepted by, which is received by Sri BP Pradhan in court. Further, Sri Bhandadev submits that his client has also paid rupees 15,000.
15,000 on 20 May 2024.
On 25/2024 by way of
my lord,
electronic transfer, bank transfer, or electronic bank transfer.
Another 15,000 prior to that.
Since a sum of rupees 50,000 has been paid towards maintenance as undertaken, and nature of the dispute is such as can be attempted to be resolved amicably, let the records be placed before Orissa High Court Mediation Center. Yes, Mr. Pradhan, I'm sending it to Mediation Center. Orissa High Court Mediation Center, who shall do the needful.
50,000.
The parties are directed to appear pursuant to notice issued by the mediator and to render full cooperation in the mediation process. Place this matter 20th August 2024. Till such time, further proceedings in CRP number 62 of 2023 pending in the court of law and judge, family court Bhubaneswar. That family court Khordha, family court Khordha Bhubaneswar kono? Bhubaneswar family court 1 or 2?
Family court.
Family court and Khordha, family court family court touch hai.
Family court 2, my lord.
तुम जाने वाले judge, family court. देखिले अपन लिखते खोर्धा एट भुवनेश्वर दैट इज टोटली मिसलीडिंग कारण खोर्धार गोटे फैमिली कोर्ट अछि भुवनेश्वर दुईटा फैमिली कोर्ट अछि भुवनेश्वर दुईटा कोर्ट अछि कोन कोर्ट
As for instance, to
जाइता लिखि फाइल करबा ले जाय गोटे ऑर्डर मिलेला गला कोन
family.
प्रैक्टिस इतने सॉल्व नहीं जान नथि गया
My lord, 2, my lord.
the court of judge family court bracketed 2 Bhubaneswar shall remain state till the next date.
Write a copy of the draft I am filing and
No, nothing. Copy of the copy of the draft be kept on record.
34.
34? Yes.
If the wife has called for transfer of the application signed by the husband.
Yes, Mr. Mishra, you are appearing.
Yes, ma'am.
The just family court.
The wife has come.
Fine.
Mediation has failed.
Mediation failed.
कौन करिया था कोर्ट ट्रांसफर करो
Patna to Bhubaneswar.
पटना टू भुवनेश्वर कर दो
नहीं आम एबिका सिचुएशन आउ किछि नाही माने लेस डिफरेंस किछि नाही कारण एवरीथिंग इज ऑन एयर कारण सब तो ऑनलाइन ले पारियो
so don't worry, you will also stay on air.
Yes.
Hela, you will also stay on air. You can float on air if you want to. The petitioner wife seeks transfer of CP number 12 of 2024 from the court of judge family court Bhavanipatna, Korahandi at Bhavanipatna, Korahandi at Bhavanipatna.
भवानीपटना रे कोर्ट अछि
No, अच्छा हो Korahandi at Bhavanipatna to the court of learned judge family court at Bhubaneswar.
केस रे किछि नाही मेरिट ओनली बिकॉज ऑफ ईगो ये आइटर
आपन तो पठारे मीडिएशन आपन को फेलला
आया
आ ईगो जे अछि
आगे रेडी बट से कोच म आइटर पास करछु तो गुणपुर पास करछु दिस इज द डिफरेंस वर्षे आगे बाहर रहिछ
prayer for transfer has been made on the ground that the petitioner is residing at Bhubaneswar with her parents after dissension arose between her and her husband. Moreover, she is also taking care of her old and ailing parents. As such, it would be difficult and inconvenient on her part to travel to Bhavanipatna to attend to the case. Prayer for transfer has been opposed by the by Sri Mishra Learned Counsel appearing for the opposite party husband on the ground that it would be difficult for the husband to travel to Bhubaneswar.
Yes, my ailing parents are there, ma'am.
To attend to the case because he also has to attend to his old and ailing parents. After considering the submissions and the relative inconvenience that may be caused to the parties, this court is of the view that it would be more inconvenient to the wife if the proceeding is allowed to continue at Korahandi. Under such circumstances, I am inclined to allow the prayer. It is directed that the proceeding in such and such be transferred to such and such court. It shall be open to the opposite party husband to appear through virtual mode by seeking necessary permission from the court. Yes.
Obliged.
Item number 36. May I please? Extension of time.
First time it has come?
Second time.
1 week time.
Right.
1 week time.
To order late 2 weeks.
Order sanction by 1 week. 1 week time. Ago bar kar do order. Yes. Oblige. Avne. तो नहीं वीकली लिस्ट रहेगा ना वीकली लिस्ट तो कौन আছে देखो পাঠাটা আগে তো আগে চারটা পাঠাটা
Pardon, my lord, item 51 of the weekly list tailors. Paper 1 week time tailors.
বড় পড়ু again দেখি
Personal difficulty, Mr. Satpathy tailors. Brother or poor brother is the best.
देखिए पढ़ो मैं I will adjourn don't worry
51.
so first there are 4 partnered matters in the weekly list I will take up those and then I will begin the orders I think you have your item 1
Yes.
somebody was appearing on the other side that day
Yes.
this is that consolidation matter
36A.
or that
Consolidation.
the additional question of law was framed we will take it up after 2 o'clock even aram kore labo kichu na so there are 4 matters thereafter we will take up orders matter this is for the entire 4 din achi dekhi karo take instruction regarding those documents which my learned senior has supplied last time. Whether the documents are genuine or not. Yes. Lord, they are genuine. Instruction has come. Is IA कितने?
The IA 473.
Can you please refer to the flag number?
473 first.
Learned State Council has obtained written instructions from the IAC of Plant Site Police Station, Rourkela, stating that the documents produced by the petitioner Amir Khan are found to be genuine. Medical documents. Medical documents produced by someone are found to be genuine. IA कितने again? Can you please refer to the flag number?
709.
Flag टा कितने देखी? Oh, flag code is the release stage flag 709.
No. এটা হচ্ছে বলতে flag G হচ্ছে 473 of 2024 as flag G.
Flag G. Flag G to 473. This is where you produce the document. Yes, Mr. Panda.
My lord,
This is where you.
I'm not very sure, my lord. Let me check. 709, my lord. I think it will be 709. 709, your lordship granted him interim.
Now, which IA is to be taken up?
That same IA, my lord. Because what happened is, your lordship granted him interim bail in that case, that IA, on 25/6 for 5 days, 27/6 to 27. That is by order dated 25.
So that has not been disposed.
No.
IA 709 of 2024. Now, how many days do you want?
Now, my lord, since he will be admitted for operation, my lord, at least 4 weeks, your lordship will say.
Date of release. Therefore, interim bail has been made on the ground that
Or 5 weeks.
the petitioner is required to undergo surgery for his ailment relating to varicose veins. As stated earlier, the medical documents produced by the petitioner have been certified to be genuine by the IE. Learned State Council fairly submits that having regard to the ground on which prayer for interim bail has been made, the court may pass appropriate orders. On consideration of the submissions, and in particular, the ground on which the petitioner seeks interim bail, I am inclined to allow the same. The IA is, the petitioner, it is directed that the petitioner shall be released on interim bail for a period of 4 weeks.
My prayer in the IA is for 6 to 8 weeks. Can I pray 6 weeks?
6 weeks. By the trial court on such terms and conditions as he may deem fit and proper to impose.
Small prayer.
Yes.
Can the order be communicated to the trial court by the registry? Because by the time I get certified copy, it will take 1 day, my lord. Since the doctor has advised him to report before the 12th, if the order is communicated and the trial court can act on that communication, since he is not in custody at Raurkela, they have kept him somewhere else. So, jo din order ho, taro din se bhai.
No, the application motion has to be made by you.
Yes. So I am praying that if this order is communicated there, my lord,
so let this order be
the trial
communicated
court to act on this order, and I'll produce the copies, then at least it will be expedited easily.
This order be communicated to the court below through electronic mode forthwith. Further, the court below shall act upon the same, provided motion is made by the petitioner. Appellate motion is made by the parliament.
And all the documents regarding surgery may be produced on the next day.
That document.
Correct. Should I लिखा दरकार? नहीं लिखे. Oh, if further the petitioner shall produce proof of surgery being undergone by him after its completion, along with all necessary documents. Yes.
Date good.
This is matter 6 week for
August 3rd week.
20th August. Yes.
And an urgent copy.
Urgent certified copy be granted.
Quickly list item number 1.
Last time we framed an additional issue.
Additional issue is
Whether the amended provision,
and I also undertook to produce that copy of the judgment.
Yes,
which in time has been delivered
by a coordinate bench.
By a coordinate bench.
Yes. No,
yes, ma'am. RSA 289 of 2016.
Yes.
It was a suit for partition. Both the courts below, so far as the purchase is concerned, holding that the transaction is hit by section 34, dismiss the suit for partition. Then the second appeal was preferred. Your Lordship may kindly turn to page 4 of that judgment. Straight to page 4, that will indicate at the top of it, accordingly it is stated that plaintiff has acquired no title or interest over the land covered under the said registered sale deed, and therefore the suit for partition at his instance is liable to fail. This has led the trial court to dismiss the suit. The plaintiff, thus being non-suited, when had carried the first appeal, the first appellate court has affirmed the said finding of the trial court, and judgment and decree passed by the trial court stood confirmed. The appeal has been admitted to answer the following substantial question of law. Whether the ground on which the courts below have dismissed the suit in holding the sale transaction under the registered sale deed dated 5/10/88 as void does no more survive in the eye of law in view of the coming into force of the Odisha Consolidation of Holdings and Prevention of Fragmentation of Land Act 2023 on 29th December 2023. So this is the direct question which has been framed there. And if your Lordship will kindly see from paragraph 10 onwards. Next page, at page 5, towards the bottom.
Yeah,
paragraph 10.
Yes.
In order to address the rival submission and find out the answer to the substantial question of law, it would be profitable to quote the provision contained in section 34 and 35 of the OCH and PFL Act 72 as those were prior to coming into force of the OCH PFL Act 2023.
We can come to page 7.
Then, yes, my lord. Page 7. When such provision of law was holding the field, recently the provisions of chapter 5 of OCH and PFL Act containing section 34 and 35 have been totally omitted by section 2 of the OCH and PFL Amendment Act 2023 and section 36A has been introduced in the statute by section 3 of the said Amendment Act, which have come into force with effect from 29th December 2023. The said provision reads as under. Your Lordship has gone through that provision. The provision of subsection 1 of section 34 of the OCH-PFL Act, as it was in the statute till 28/12/2023, created the bar. Said provision of subsection 1 of section 34 created the bar for transfer of partition of the agricultural land in a locality so as to create a fragment. If we pause, my lord, it also relates to transfer.
Alienation.
Transfer, the word used is transfer. Transfer and partition. Here this was a suit for partition, therefore it has been used like. Such transfer of fragment only to a landowner of contiguous chapter. However, by subsection 1 of section 34 of fragment to a person other than the landowner of a contiguous chapter or partition, provisions of section 34 has been made statutorily void. As for provisions of subsection 3 of section 34 of the Act, such transfer of fragment or partition creating fragment was permissible only when the same was with the prior permission of the competent authority. As per subsection 2 of section 35, in order to see that by such transfers or partition, fragmentation land is not done and thus prevented, as by such transfers the very objectives sought to be achieved under the whole scheme of the OCH and PFL Act by such arduous exercise at the huge expenses from the state exchequer is not frustrated. So the collector was given the power to evict said person coming to possess as the violator of law. A careful reading of the Amendment Act 2023 containing 3 sections would reveal that legislature has omitted such provisions as to the bar and the ancillary provisions of section 34 and 35 as those were in OCH and PFL Act. Thus, the fragmentation is no more a contravention to invite invalidity to the transaction and face the eviction from the land in question. The legislature's intention thus it's clear that prevention of fragmentation is now not at all the focus. It is therefore that the provision of section 36A has been introduced in the statute that all such transfers or partitions of agricultural land in a locality creating fragmentation under the existing law prior to amendment would be treated valid. Only the saving is to the closing cases where the eviction had been made by the collector in subsection 2 of section 35. The omission of the above provisions contained in the original act is without any further reservation. The omission of said provision of section 34 and 35 and more so due to introduction of section 36A thus leads to the interpretation as if the said provisions were never there in the statute. The introduced provision under section 36A is found to be general and sweeping one. Upon reading of the provision, it has to be construed as if to be effective notwithstanding the date of transaction. The legislature has introduced this provision of section 36A after omitting the provisions of section 34 and 35 in the original act in order to validate all such transactions which were otherwise invalid for the contravention of the provisions contained in section 34 and 35 of the act when those were in force till 28/12/2023. So by such provision of section 36A, all such transactions which were even void for contravention of section 34, when those were in force, are treated as valid and now no more can be so declared. This covers all such cases where even declaration has been made. It only doesn't put the clock back whereby such declaration eviction has been effected. Therefore, now when we do not find such provision in the statute, it would not be permissible to hold any transfer in contravention of the said provisions as those were before the omission as void. It is well nigh the settled position of law that the change in law after the disposal of the original proceedings can well be taken note of in the pending proceedings arising out of the original proceeding. That being so, in view of the coming into force of the OCH-PFL Amendment Act 2023 by omission of Chapter 5 containing Section 34 and 35 and introduction of Section 36A in respect of the provision contained in Chapter 5, having the nexus with the provisions and the acts, deeds and effects which had occurred due to operation of those omitted provisions, the substantial question of law is answered in favor of the plaintiff. That finding of the courts below that the sale transaction in favor of the plaintiff and the registered sale deed executed by the defendant and his mother is void and inoperative for contravention of section 34 and 35 of the Act cannot sustain. Well, the another judgment also the same language is there also. Correct. Language is also same. Correct. And I have on the other day I had given a small note. So far as the facts are concerned.
Note was there. I had seen that note. Yes. What is your reply?
Lordship, I will confine my argument only to submissions. One is the statutory provision 36A, which took away all the past transactions and got those transactions valid, except the cases where eviction has been done by the collector. One. Second, it has been settled by this Hon'Ble Court that past transaction valid so far as section 30.
It's a validating provision.
But your Lordship, validating provision. So I have nothing to say. This is settled question of law. This is clear.
All right. Hearing concluded, judgment reserved. Yeah.
Item number 2.
In fact, I had completed my side of the argument that just to replace with user right of a well.
Yes, I remember.
In fact, it was only
You're referring to power of attorney.
Declaration title has been made. So it is not there in the document itself.
Yes.
Yes, ma'am.
For convenience, I have got a copy of that exhibit 2.
LCR is also there.
LCR is there. It is there.
The Lordship can turn to page 2 of the trial court judgment, where the genealogy is reflected.
Okay.
Only for the purpose of illustrating the fact.
Yes.
Lord, as per the plaintiff averments, both.
Just to recapitulate, you are the plaintiff or?
Yeah, I am the plaintiff.
You are the plaintiff.
I am the plaintiff.
You have not given the name of the common ancestor. You
Yes.
started straight away with.
But it is in the plain.
ठीक है.
Vidyadhara is the common ancestor.
किए थे?
Vidyadhara.
लिखा ही नहीं.
Lekha in genealogy lekha.
Okay. Vidyadhara.
Having two sons, Hon'Ble and Ramchandra.
I had passed over such a genealogy in the record, must be in the record.
Oh, that genealogy, yes. Anyway.
Hon'Ble and Ramchandra. Lord, it is also revealed from the plaintiff assertion that both Hon'Ble and Ramchandra have partitioned their ancestral property, including the present suit land, long back before HAL settlement of the year 1962. And during HAL settlement operation, the particular suit plot stood recorded in the name of Ramchandra separately, that is the branch of plaintiff and defendants. Separately, in the year 1962, the HAL record of right. But it is further case that there was a registered deed of partition on 16/6/1969 by the Exhibit 2 in between the sons of Ramchandra, where 7, including the present suit land, suit well is situated over the suit plot, which is fell to the share of the defendant. So far as the registered deed of partition by the Exhibit 2 dated 16/6/69 is concerned, there was no restriction on the said deed that we have no right over the suit well. Rather, it is clear and unambiguous from the recital of the Exhibit 2.
What is Exhibit 2? This is Exhibit 2.
Yes.
Yes. What is the language? whether oral evidence would be admissible in view of the any confusion in the language or not, or whether it is clear and unambiguous.
Sita mobile exhibit 2 nai so far as
Mobile
finding way.
mobile ଅଛି।
Your lordship have a glance only the finding of the appellate.
ସେଠୁ ନଉନାହାନ୍ତି।
ଆଜ୍ଞା। Your lordship have a glance to the finding of the appellate.
ନା ନା ଆମେ ଏଇଟା ଦେଖିବା ଫାଇଣ୍ଡିଂ କୁ ପରେ ଯିବା।
ଆଜ୍ଞା।
ଏଇଟା ଅଛି ବୃତ୍ତିକୁ କ ଖ ମୁତାବକ 2 ଗୋଟି କଛ କରି ଆମ୍ଭମାନଙ୍କ ମଧ୍ୟରେ ବଣ୍ଟନ କରି ଦେଇଥିବାରୁ ଆମ୍ଭେ ମାନେ ଅପେକ୍ଷାରେ ଆପୋଷରେ ଆଜିକୁ 20 ବର୍ଷ ହେବ ଆମ୍ଭେ ପକ୍ଷ ମାନେ ଆମ୍ଭମାନଙ୍କର ତପସିଲ କଛ ମୁତାବକ ଘରବାରି ବୃତ୍ତିରେ ପୃଥକ ଭାବରେ ମାଲିକ ଦଖଲକାର ଅଛୁ। ଏଥକୁ ତଫସିଲ ବୃତ୍ତି ସରକାରୀ କାଗଜାତ ମାନଙ୍କରେ ଇଜମାଇଲି ରେକର୍ଡ ଥିବାରୁ ଇତ୍ୟାଦି ଇତ୍ୟାଦି ଗଲା ଏଇଠି ଆମ୍ଭମାନଙ୍କର ମଧ୍ୟରେ ବଣ୍ଟନ ହୋଇଥିବା
ଆମ୍ଭ ପକ୍ଷମାନଙ୍କ ତଫସିଲ କଛ
ନା ତଳକୁ ଅଛି
ଘରବାରି ବୃତ୍ତିରେ
ଏଥିରେ ବିଦ୍ୟମାନ ଥିବା ପୁରାତନ ପକ୍କା କୂପ 1 ଗୋଟି ପୁରାତନ ଆଟୁ ଘର
ପୁରାତନ ଆଟୁଘର ଏକ
ଖରାଖାଇ ଛତାର ଘର
ଖାଇ ଛପର ଘର ଏକ ବଖରା କବାଟ ଚୌଖାଟ ସହିତ ଆମ୍ଭେ ମୂଲ୍ୟ ଏତେ ଟଙ୍କା ଆମ୍ଭେ ଏକମ ପକ୍ଷ ବଳଭଦ୍ର ସାହୁଙ୍କ କଛ ସମ୍ପତ୍ତି ଘରବାରି ପକ୍ଷେ ଆମ୍ଭେ 1 ନମ୍ବର ପକ୍ଷ ବଳଭଦ୍ର ସାହୁଙ୍କ କଛ 275 ନମ୍ବର ଖସଡ଼ାରେ ଥିବା ଘରବାରି ବୃତ୍ତିରେ ବିଦ୍ୟମାନ ଥିବା ଉପରୁ 2 ପକ୍ଷ ଜଗନ୍ନାଥ ଦ୍ୱିତୀୟ ପକ୍ଷ ଜଗନ୍ନାଥ ସାହୁ ଓ ତାଙ୍କର ଉତ୍ତରାଧିକାରୀ ମାନେ ପୁରୁଷାନୁକ୍ରମେ ଉକ୍ତ କୂପର ଦକ୍ଷିଣ ତରଫ ଚାନ୍ଦିନୀରେ ପ୍ରବେଶ କରି ଜଳ ବ୍ୟବହାର କରିବାର ଅଧିକାର ରହିଲା ଯେ ଆମ୍ଭେ ଏକମ ପକ୍ଷ ବଳଭଦ୍ର ସାହୁ ଓ ଉତ୍ତରାଧିକାରୀ ମାନେ ଜଗନ୍ନାଥ ସାହୁ ତାଙ୍କ ଉତ୍ତରାଧିକାରୀ ମାନଙ୍କୁ ଉକ୍ତ କୂପରୁ ପାଣି ବ୍ୟବହାର କରିବା ଅଧିକାରରୁ ବଞ୍ଚିତ କରିପାରିବୁ ନାହିଁ କି କରିପାରିବେ ନାହିଁ କଲେ ହେଲେ ଫୌଜଦାରୀ ଆଇନ ଅନୁସାରେ ଦଣ୍ଡନୀୟ ହେବ। ଉକ୍ତ କୂପରେ ତାଙ୍କ ଉଦ୍ଧାର ମରାମତି କାର୍ଯ୍ୟ ଉଭୟ ପକ୍ଷ ବହନ କରିବାକୁ ତଫସିଲ ଖ ଚିହ୍ନିତ କଛ ଆମେ 2 ନମ୍ବର ପକ୍ଷ ଜଗନ୍ନାଥ ସାହୁ 115 ଡିସମିଲ 5 କଡ଼ିରେ ଥିବା ବିଦ୍ୟମାନ ପୁରାତନ ଆଟୁଘର 1 ବଖରା କାଇ ଛପର ଘର 1 ବଖରା କବାଟ ଚୌକାତ ସହିତ ଆନୁମାନିକ ମୂଲ୍ୟ ଏତେ ଟଙ୍କା ଅଟେ। ଆମେ ପ୍ରତିପକ୍ଷ ମାନେ ଉକ୍ତ କଛ ମୁତାବକ ତଫସିଲ ସମ୍ପତ୍ତିରେ ପୂର୍ବବତ ଅଦ୍ୟବାଦୀ ମାଲିକ ଦଖଲକାର ରହି ନିଜ କଛ ସମ୍ପତ୍ତି ମାନଙ୍କୁ ଆମ୍ଭମାନଙ୍କ ମଧ୍ୟରେ ପୃଥକ ରେକର୍ଡ ଦର୍ଜ କରେ।
ପାଣି ଶୋକ ପାଣି ଶୋକ yes so କୋଉଠି ଟାଇଟଲ ସେ ତାଙ୍କ ଉପରେ ଦିଆଗଲା ବୋଲି କୁହାଗଲା
ନା କୋଉଥିରେ recitals from the recitals for exhibit 2 nowhere it is mentioned that defendant is the exclusive owner or the plaintiff has only right to draw the water
ସେ ଲେଖା ହେଇଛି ତ
ଏ ଲେଖା ହେଲା ଉତ୍ତରାଧିକାରୀ ମାନେ ସମସ୍ତେ ନବୁ and also both have right to repair the well
ଯେହେତୁ ଆପଣ ବ୍ୟବହାର କରିବେ ତେଣୁ ଆପଣଙ୍କ ବି ଦାୟିତ୍ୱ ରହିଲା ଇଏ କରିବେ କିନ୍ତୁ କୂପଟା ଆପଣଙ୍କର ଟାଇଟଲ ତା କୂପ ଉପରେ ରହିଲା ବୋଲି କୋଉଠି ରହିଲା
it presupposes that we have right to repair by our both joint expenditure that is what has been mentioned in the appellate court judgment. So far as the right of the successor of the plaintiffs are concerned it is clearly mentioned that we have right to draw the water but so far as right over the well is concerned it is mentioned in the recital that we have right to repair both the well by both the parties not that the plaintiff or defendant has exclusive right over the well and we have no right to maintain the same only to draw the water and nowhere in the recital from the exhibit 2 it is revealed that the plaintiffs or their predecessors have only exercised the right to draw the water. That is where the appellate court has come to a finding. Your lordship have a glance only page 13 of the appellate court judgment.
Yes.
Lord, I am pressing paragraph 9.
Yes.
From 9th line from the top. On close perusal of exhibit 2.
Yes.
On close perusal of exhibit 2 as it appears, the terms thereof are clear and unambiguous to the effect that the shoot plot along with the well in question is situated therein find mentioned in Kokacha of the deed of partition, which has been allotted in the share of late Balabhadra. It is also stipulated therein that the original plaintiff number 1 will use the water of the shoot well as well as right for all times to come and for generation to generation without any hindrance from the side of Balabhadra or his successors in interest in any manner. That apart, both the brothers would jointly renovate and repair the suit well from time to time, with the cost whereof will be borne by jointly. Thus, it would be ridiculous that the Balabhadra had acquired exclusive right over the suit well merely because the well situated over plot number 275, which stood allotted in his share in Exhibit 2. Right to use water of the suit well is a right inherent with the concept of ownership of the property in question. To add to, when their joint right to use water in annex to the corresponding duty and obligation to the co-sharer, the plaintiff number 1 with regard to repairing and renovation of the suit well jointly with late Balabhadra, read with the fact that the well in question is the ancestral well of the parties. I am of the considered opinion that the recital of Exhibit 2 exclusive ownership of late father of defendant over the suit well is not established.
Correct.
Milord, so far as this finding is concerned, it is also corroborated with the oral evidence, and that finding is at page 17. Lord, my blessing, Lord.
No, I am asking you a
Yes.
fundamental question.
Yes.
If, according to the first appellate court,
Yes.
the recitals of that Exhibit 2 were adequate,
Yes.
then further oral evidence
No.
was not required to be gone into.
Yes.
91 is a bar,
Yes.
isn't it? But nevertheless, you can begin.
So that is what I impressed to your lordship is that with regard to the fact that the well in question is in existence since time immemorial from their forefather.
That is not disputed by anybody.
Yes, because of the fact that it belonged to Vidyadhar. That well,
The common ancestor.
common ancestor. From that time, both the brothers, that means Bonmali and Ramchandra, were using the same. More so, except and except plaintiff and defendant, other recorded owners, that means the sons of Bonmali also, using the suit well for using the water. That is why, in the registered deed of the year 1969, the recital goes to show that we will draw water from the same as well as maintain the same. That presupposes we have right over the well, save and except over plot number 275. That is why the Land Appellate Court has come to a conclusion with a stipulation. Your Lordship have a glance also on the alternate the decree of the Appellate Court with a finding that we have even no exclusive right to draw the entire water. There is a restriction in the judgment. The restriction is plaintiff have right title interest over the suit well, and they have also right to over the suit well through pipeline fitted with the motor without causing any detrimental equal right of the defendant. The Appellate Court has also imposed a restriction on me not to draw the entire water to the detrimental of the defendant. That is in consonance with the Exhibit 2. Therefore, my submission would be, so far as the findings of the First Appellate Court with regard to the fact that we have right over the suit well is well proved by way of Exhibit 2 and other oral evidence. And that needs no interference.
Any reply? Or that only. Hearing concluded, judgment is okay. Item number 3.
Your Lordship, if I may refresh the facts of the case.
Who is the other side?
Your Lordship, no one appeared on the last time also.
No one had appeared.
No. Your Lordship, this is a confirming judgment. The appellant is the defendant number 5. Your Lordship, on the prior occasion, I had submitted the genealogy in the of the.
ଗୋଟେ କାଗଜ ଦେଇଥିଲେ
ଆଜ୍ଞା
ଦେଲ yes
Your Lordship, so Govinda Mahanta is the common ancestor from whom the 3 branches of Chandra.
This is suit for partition.
Yes, Your Lordship, it was a suit.
You are the plaintiff or defendant?
Defendant number 5.
Defendant number 5. Okay.
Yes, Your Lordship.
Defendant number 5. अच्छा, हो ठीक है. चंद्रमोहन, शत्रुघ्न, and Harihar. Yes.
Harihar, Your Lordship. The plaintiffs belong to the branch of Shatrughna, and the defendants belong to the branch of Chandramohan. Defendant 1 to 6 belong to the Chandramohan branch, and Harihar himself is defendant number 5.
Yes.
The plaintiff's case is that, Your Lordship, that the plaintiffs and defendants have no other joint land except the suit land. And in 1951, the suit land was purchased by all the 3 brothers jointly by the registered sale deed. After the death of Shatrughan in 1965, his legal heirs continued possessing them jointly. In the plaintiff's case is that the plaintiffs were not allowed to cultivate the suit land on 10/7/1991, for which they filed they asked for a partition, and when the defendants refused, they filed a suit for partition.
Yes. What happened?
The defendant's case is that, Your Lordship, that there was a prior partition in 1959.
There was a prior partition.
Yes, Your Lordship, between the 3 brothers.
This is the judgment of
Property is not the only property.
Additional civil judge unit division. Yes, we go. All right. Technical 26 of 91. Isn't it?
Yes. Okay.
All right. So what happened? The suit was so they claimed a prior partition. So issue number 3.
Prior partition, yes.
Issue number 3. How was it proved? Let us see issue number 3. The finding.
Yeah.
Issue number 2 as a issue number 3 ku chalo. The presumption of law. Yes. Say to pado. Page 8 2. Page 7 2. Page 7 to the last portion.
The presumption of law is that the property of Hindu family is joint unless contrary is proved. In order to establish jointness, plaintiff PW1, who is looking after the suit for other plaintiffs, has filed the sale deed Exhibit 1 and rent receipts, that is Exhibit 2. And Exhibit 2.
This sale deed is the deed by which you had purchased the property. All of you had purchased the property.
Yes, yes.
Okay.
The admitted position is that that Shatrughan, Chandramohan and Harihar had purchased the suit land jointly from Vaishnava Sethi on 15/3/1991 by registered sale deed Exhibit 1. But case of the defendant is that there was partition between 3 brothers of the entire property, that is ancestral property, and purchased property, that is the suit land, on 23/59. The ancestral property was in Keonjhar, Mayurbhanj district, and the suit land is at Cuttack. In that partition, the suit land fell in the share of Shatrughan, and the property of Keonjhar and Mayurbhanj fell in the share of Chandramohan and Harihara. As Shatrughan expressed his willingness to take the share at Mayurbhanj and Keonjhar, his health did not suit the climate. The earlier partition was cancelled on 23/3/59. Again, and on 23/3/59, again a partition was made in which Shatrughan was allotted land in Keonjhar and Mayurbhanj district, and the suit land fell in the share of Chandramohan and Harihar. The son of Chandramohan, who are D1 to D4, are not contesting the case and have been set ex parte. The written statement filed by contesting defendants PW5 and PW6 does not reveal the date of partition. Both the written statement discloses that there was partition in the year 1959. The same amounts to material omission. Moreover, D6, who is the wife of Chandramohan, does not speak that the first partition took place on 23/59, and therefore again there was second partition on 23/3/59. Your Lordship, should I come to the finding?
Yes.
Your Lordship, should I come to the finding of the court? The trial court. It is on page 13, Your Lordship, that taking into consideration the entire documentary and oral evidence, it is observed that the suit land was not partitioned by metes and bounds, and the issue is answered negatively in favor of the plaintiff.
This means prior partition.
Yes, Your Lordship.
Yes. Then
Your Lordship.
he decreased the suit.
Decrease this.
Allotting? What is this?
Allotting
1/3 share.
1/3 share.
1/3. All right. So who carries the matter in appeal?
The defendant number 5.
What happened? On what ground? challenging that finding.
Yes, your lordship, challenging.
That is based on overall evidence.
Additional.
That is based on overall evidence. The court found did not believe it. So what is wrong in that finding?
Your lordship, there was a exhibit.
Unregistered document.
Unregistered.
Unregistered document. What is the value of that unregistered document?
Your lordship, it may not hold, it may not be held admissible in terms of the share, but it can be used as a collateral transaction for.
Here, what you are referring to the collateral transaction is the main transaction.
Your lordship.
You say that is wait. You first hear the question so that you will be able to answer it. The transaction that you are referring to, which is that exhibit 2. Exhibit 2 na kete?
Exhibit B.
Exhibit B, sir. So that you say that it can be used for collateral purposes, all right? Doesn't matter. But here, what you are referring to is not a collateral transaction, but the main original transaction, which is the prior partition. According to you, there was a partition on 23rd March 1959, isn't it?
Yes, sir.
That is what you said. First there was on 20th, and then 3 days later there was another partition. That was disbelieved by the court. What is wrong in that finding? Let us see the appellate court order.
The lordship, there were further evidences produced during the appellate stage under order 41.
27.
Yes, your lordship.
Let us see.
Your lordship, para 7 in page 8 of the appellate court judgment.
Page 8. Para 7, yes.
Before going to discuss the merits of the case, it is to be decided whether the petition filed by the appellant under Order 41, Rule 27 CPC can be allowed, and documents filed along with the said petition can be admitted as additional evidence. Your lordship,
what are those documents?
Your lordship, those are the sale deeds relating to the other lands.
So how do we prove the prior partition?
Your lordship, but if that shows that the suit land was not the only joint property.
No, as I have read from the trial court judgment, the properties situate in Keonjhar and Mayurbhanj districts are the ancestral properties.
Yes.
The suit land was purchased jointly by the 3 brothers, which is at Cuttack or Jashpur, whatever. Isn't it?
Yes, yes.
So,
your lordship, then that will amount to partial partition, which is not allowed under the law.
very good. So, how do we prove prior partition?
Your lordship, if you come to page 11, the sale deed, the first document is a certified copy of the sale deed of page number 13, the sale deed of the year 1985.
Good.
The lower appellate court.
Where are you reading from?
The next sale deed is of the year 1985, sir. Page 13.
Kete? 1, 2, kete line pare?
Sixth.
Yes, next sale deed.
The next sale deed is of the year 1985, by which one of the plaintiffs sold a portion of the suit land to one Sahib Munda. In the recital of the said sale deed, it is mentioned that the said properties were jointly recorded in the names of the 3 brothers Chandramohan, Harihar and Shatrughan, and they were possessing as per this allotment, which no doubt indicates that there was a severance of joint status. So there
is severance. He accepts that there was severance, but there was no partition by meets and bounds.
Your lordship, for that last time also, your lordship, I took time for the sale to go through the sale deed. We've contacted the client. The client hasn't been able to come due to this. If your lordship gives me a day after tomorrow, I'll.
Yes, that is not an issue. Don't worry. But what do you want to find out from that sale deed?
Your lordship, that will indicate that there were the ancestral properties and the joint family properties, and since prior partition is not permissible under law, this suit would not have.
Partial partition is not permissible.
Partial partition is not permissible under law. This suit should not have been maintainable, and there has been a material separation on the part of the plaintiffs for not having disclosed that these properties were also existing.
All right. Not further arguments in part. Let's this matter. We'll take it up next week. You prepare well.
Much obliged.
Very good.
I don't know, 4.
We commencing कौन है? 15 जुलाई. Yes, sir. Come. I'm just passing it over. When can you argue? I don't want to take it to next week. I'll complete it this week. Can you get the cell deed which you are referring to? Or it will be called out on Friday. All right. Indicate को रख दीजिए ये Friday का. Pass over ही करो. Yes.
Item 4.
Mr. Samudraya, the wrong LCR has come.
Sure, any other day.
It appears the court below has sent the wrong LCR. Yeah. Office to the court below be directed to transmit the correct LCR. Let's this matter next week or no, week time. On 22nd July. Week commencing 27th.
22nd.
22nd. Orders. कितना orders है चिरू बाबा? Dashta na ba? Aji dashta.
5 milots. On last occasion there was 3 IES milots here. As the delay was of a long period, your lordship has said that kept it for today for final hearing milots. Though I have gone through the records, I need some more time to research milots. This is a confirming judgment wherein there was a suit for permanent. I am the defendant in the case. The suit property is alleged that it was my father's suit property. It was my father's suit property. The plaintiff is the purchaser. My mother sold it.
Suit for what?
Suit for permanent injunction and restraining the defendants from interfering with the peaceful possession of the plaintiff, milots. Now, what has happened, milots? What we say that after the death of my father, the property should have devolved equally with the widow and the daughters, whereas my mother has sold whole of the property to the present plaintiff, who is the Vendi, milots. So our only question of law which revolves around is, milots, whether the suit property to the whole of the extent can mother sell it, showing the legal necessity or not. When we were the survivor-ships, whether it can be sold off to our extent also or not. That is the only question of law, milots. Plus, I need some time to further research in that matter, milots.
All right. Next week?
Plus next week, milots.
As prayed for by Airline and Counsel for the petitioner, let's this matter next week. Very difficult.
Milots.
Very difficult.
Plus
confirming judgment.
We cannot.
Unless I find an arguable case,
milots.
I'm not going to condone the delay.
We cannot better the case, milots.
No, what was that? What was?
Milots.
Yes. Try to find out points.
Milots.
Make research. Try to find out to convince the court. I have opened my mind. Try to persuade me to reverse my own mind. I'm willing to do that. I'll be happy to do that. Yes.
Item 6.
Two of the appellants have died, my lord.
You are the appellant?
My lord.
Your name doesn't appear.
On behalf of Vidyadhar Mishra.
So this 841, 842 and 843 are here. Kete delay kete each?
But delay for 3 years, my lord. During COVID, she died, my lord.
Kebe mori cause of action does a period with her father.
Again, 17/5/2020.
17/5/2020.
Again, March 2020, COVID started.
All right. So, it according to. Please tell me the IA numbers.
But IA number 841.
Which is the condemnation of delay? Which one?
843, my lord.
843. This is an application for condemnation of delay in filing of the substitution petition. It is stated that appellant number
1G
died during pendency of this appeal on 17/5/2020. as the COVID-19 pandemic, the petition for substitution could not be filed within time because of the COVID-19 pandemic during that time. Considering the above, the delay in filing of the substitution petition is condoned. 841 or 842, na? 841, 842. This is an application for substitution of appellant number 1G, who died on 17/5/2020. It is submitted that the right to sue survives in favor of his legal heirs, who have the details of whom have been schedule भी करना था.
petitioner ଅଛନ୍ତି.
ଗୋଟେ schedule ତ କରିବେନି କି କେସ ମାନେ ବୋଲି.
ଆଜ୍ଞା ସେଇଟା petitioner they have filed the wakalatnama.
ହେଲା ଗୋଟେ schedule ତ କରିଦେଲେ ସୁବିଧା ହୁଏ ଦେବ ବୋଲି. That I understand.
There 1GA to 1GH.
ହଁ ଆପଣ ପିଟିସନ ଟା କରିଛନ୍ତି ଲେଖିଛନ୍ତି ଯେ ଲାଡି ଲିଙ୍ଗରାଜ ପାତ୍ର incident through his legal heirs and others କଣ ସେଇଥିରେ ଜଣା ପଡିଯିବନି କିଏ କିଏ କଣ.
ତାପରେ in the matter of so they are the petitioners 1GA to 1GH.
ସାର୍ କୋଉଠି ସେଟା ଲେଖା ହେଇଛି ସାର୍?
ସେଇ ତା ତଳେ 841 ରେ
ହେଲା the details of whom have been mentioned in the cost. Under such circumstances, allow this abatement is set aside and the appellant numbers 1G-small a to 1-G-h are substituted in place of the appellant. This is appellant number 1G. Yes.
The other substitution appellant 1H died. But
either 844, 845, 846.
46. কিন্তু সেইଥିରେ death in 2018.
2018.
She is the only married daughter.
Condonation of delay টা কেতে?
846.
846. ହେଲା. This is an application for condonation of delay in filing of the petition for substitution of appellant number 1H. Stop. It is stated that he died on 12/5/2018, leaving behind his daughter. It is submitted that because it is stated that because of absence of any other male member in the family, as also the subsequent COVID-19 pandemic, she could not take steps for being substituted. Considering the grounds cited, I am inclined to allow this. I am inclined to accept the same. The I is allowed. The delay in filing of the substitution petition is hereby controlled. ତା ସାଙ୍ଗରେ ଆର ଦିଟା ଅଛି କେତେ 844 ଆଉ 845 844 45 ଟା abatement substitution ଟା allow କରିଦିଅ substitution setting aside abatement. Yes. ଆଉ କଣ ଅଛି
ସେଇ ଦିଟା ସେଥିରେ consolidated cost title I will file.
ଏ ଅର୍ଡରଟା ଫର୍ମାଲ ଅର୍ଡରଟା ହବ consolidated cost to be filed within 3 working days. Yes. It has been admitted.
Yes, it has been admitted.
Other side has appeared. LCR? LCR is not there probably.
23/8/2004 it was admitted.
LCR
Order 6.
LCR আসেনি কিন্তু. You call for the LCR. LCR is needed.
LCR lordship fixed date for hearing if it is lordship.
ठीक है हम देखिए तो सीधा LCR टा मांगी दो कौन सी सब कविता आसियो. It is seen that the appeal was admitted by order dated 19/11/2004.
23/8. Order number 6.
Sorry. However, LCR was not called for. Since the matter is otherwise ready for final hearing, list this case, list the appeal on 29 July, in the week commencing 29 July. LCR be called for. Yes.
Item number 7.
Plaintiff appellate against a confirming judgment, appeal has been admitted, and at the time of admission, as an interim measure, status quo order was granted. Lord, I have filed an application for extension of status quo order, my lord.
Why was it required? Why is it required to be extended? So, what period present?
Probably it was listed, my lord. Initial order was passed on 25/8/2005. Thereafter, on 14 in 2000.
Status quo as on today with regard to possession shall be maintained.
Yes,
it will be open for the respondents to seek for variation of this
Yes,
order.
Lord.
So they have not sought for any variation.
No more.
So this continues. Why do you need a separate?
Lord, but they are creating disturbance. That is why I have filed a petition. What I beg to pray, my lord, since appeal is of the year 2005, your lordship may fix up a date for hearing, and interim order which was initially passed, that may be continued.
All right. Okay, who is opposing you in this case?
Patti, my lord, NC Patti.
Is no longer appearing. Somebody kiye tanga office ra kiye appear korthu. Sri S.N. Mahapatra Land Counsel for the appellant is present. He submits that the appeal is otherwise ready for final hearing. There is no appearance from the other side. Place this appeal in the week commencing 29 July. Interim order passed on 25/8/2005 shall continue till the next date.
Obliged.
Item number 8.
Yes.
I am appearing on behalf of the respondent number 228, my lord. My lord, may I kindly have a glance at the last order, my lord.
That is exactly what I am looking at. Which has not been complied with as yet. That is also I have understood. And that is the reason why I am going to dismiss your appeal.
My lord, I am appearing for the respondent, my lord.
So why are you bothered? Why are you bothered?
My lord,
Again.
I beg your pardon.
Yes.
On behalf of Mr. A.K. Nanda, the petitioner is a very old ailing person, aged about 85 years. He is unable to move out and his family members are staying away. He wants praying for 2 weeks time to file the substitution petition.
Your time has been actually 7 months time they are. Do we come 7 months time they are.
Last chance 2 weeks time may kindly be.
Time is allowed till 1 week time is allowed as a last chance to take steps for substitution of respondent numbers 2 and 7. Yes. Place this matter in the week commencing 22nd July.
Item number 9.
Obliged. Obliged.
Item 9, Baba.
As per the last order, we were to file an application under Order 41 Rule 27. We have done the same. However, the same will be pressed at the time of hearing. The settled position of law.
Settled position of law.
Decision also.
মানে যেতবে অর্ডার 41 রুল 27 ফাইল হবে সেটা লাস্ট শোনা হবে বলি সেটেল পজিশন
It's yeah.
জানি কোন আমি জানি না তুমি কোন তো আগে
This is
সব জানিছি বলি বাধ্য
this is a decision of 2012 by the
Yes.
Apex Court. At para 52, I am serving a copy of Lordship. Copy of Lordship.
Yes.
Copy of the date and Order 41 Rule 27.
জজমেন্ট কপিটা কোন তাহলে কোন হচ্ছে
Order 41 Rule
রুল 20 হ্যাঁ
27
হ্যাঁ
petition.
এটা কোর্টে কইলে যে যেতবে ফাইল হবে সেটা লাস্টে শোনা হবে বলি
At that stage of hearing.
At this stage হ্যাঁ we are at this stage of hearing
आज ये orders रहे
oh see ordersটা সে ছাড়ো সে you don't go by the nomenclature. That is the nomenclature used by the registry. Why are you worried about that? What is the matter?
The matter.
Is it 2009 matter?
2009.
Is it other side has appeared?
Other side has appeared.
It has been admitted?
It has been admitted.
Substantial questions of law have been framed?
Substantial question framed.
So it's ready for final hearing?
It is ready.
That's all?
A date may be fixed for final hearing. We'll press the
Then
final hearing.
message interim
And para 52,
page 33.
I may be wrong. I don't mind saying that I'm wrong. I'm not a person who will mind saying that I'm wrong. ମତେ ଲାଗିଲା କି ବୋଲି ହଉଛି କିଛି ନାହିଁ ଲରେ ଆଜ୍ଞା ସମସ୍ତେ ସବୁ କିଛି ଜାଣିଛନ୍ତି ବୋଲି କେହି କହିପାରିବେନି ଦେଖିବା ପଢିଲେ thus from the above it is crystal clear that an application for taking additional evidence on record at an appellate stage even if filed during when to at the time of final hearing of the appeal at a stage when after appreciating everything. So whether that evidence is required to pronounce judgment or not, that is the only thing that the court is required to see. So when do you want? Yes.
The copy whatever time it is, document
So copy you serve a copy. Get a copy of the which is that miss case?
It is miss case number IA number 376 of 2024.
376 of 2024. Get a copy of this petition be served upon Tenant Counsel appearing for the respondents. Place this matter for final hearing on in the week commencing 5th August. 5th August. LCR achi na nahi dekhi. Is the LCR there?
LCR asin.
In the meantime, the court below be asked to transmit the LCR so as to reach this court before the ensuing date.
Your Lordship, I will receive that copy if that will be liable and will consider that the time of hearing and then not be filing any objection on that.
No, I have not passed any order.
Your Lordship.
It is simply there. Normally, that is what.
How if court feels that document is necessary could not be produced despite due diligence, then.
But even otherwise, if it is the court file, even if it could not be produced despite exercise of due diligence, still then the court finds that it is necessary to pronounce a judgment, then it can.
That is there. That
Yes.
that is the judgment.
Yes.
Act note 10.
Pass over.
Act note 11.
In item 11, the court fee having been paid, that may kindly be accepted, and I find from the appeal memo that the.
When was the court fees were filed late?
Yes.
So you'll have to, probably there will be a delay. You'll have to seek condonation.
No, the extension of time petition was filed.
Oh, was filed?
Yes.
Was it allowed?
That was perhaps not.
No, 4 weeks.
considered.
2016 allow itala. 4 weeks time. So.
But in the meantime.
You may have to file a petition for condonation. When does the appeal become ready?
I will have to file an application for acceptance of the court.
Acceptance? By condoning the delay. The appeal becomes
Filing.
delayed.
149 petition since was filed.
You see, the appeal not become delayed.
Yes.
Without court fee, it is no appeal.
Yes.
So, in the
that 149 is there.
So, have you filed any petition? Was it allowed?
Yeah,
I don't think.
it was.
4 weeks time was allowed. You did not comply with that order. So.
Further application is required.
Yes.
For acceptance by extending the time.
Sri Das Learned AGA seeks time to file appropriate petition for acceptance of court fees / condonation of delay. I'll grant only 1 week time.
Sir.
List this matter in the week commencing 22nd July. Application, if any, be filed in the meantime.
Item note 12.
It is made clear that no further time shall be granted.
Item 12, appeal has already been admitted. Stay of execution case till date. That may be extended.
No, AD back, not back from respondent 1B.
Postal
tracking report আছে বড় দেখে যাবা sufficient যদি এইতো করব item delivered. Postal tracking report shows that the postal article containing the notice was duly delivered to the respondent.
1B.
Respondent number 1?
B.
Capital B.
Stay of execution till date. Last order 2/24
Notice, though sufficient, notice is, however, there is no appearance from the side of the respondents.
IA number 431.
List this matter in the week commencing August.
The week commencing 12th August.
12th August?
LCR ଟା ଆସିବ ଆଉ stay ଟା continue
Up to date, LCR be obtained. LCR be called for. LCR be called for. State ଟା କୋଉଠି ହେଇଛି?
sir last order 2524
Interim order.
dated 2524
Dated 2/5/2024 shall continue till the next date. Item number 13.
13, my lord, notice was issued on the delay, condemnation of delay.
This is also
2017, my lord. And one day, my lord.
No, but notice is sufficient. No,
Notice sufficient.
Are you appearing for the respondent?
1 and 2.
1 and 2. Nobody is appearing for respondent number 3.
Three, but notice sufficient is address is not there. Noting achi.
Address not there sufficient kim dela.
Fresh notice never.
Fresh notice never go to the delay pe kon kara jibo. There's a statutory appeal you can't reproduction is.
Respondent number 1 expired, my lord. We have filed memo.
You have to take steps. Learned counsel for the appellant undertakes to file fresh requisites for issuance of notice on respondent number 3. Respondent number 2, was it?
No, my lord, the respondent number 3.
3. Respondent number 3 within 3 working days. By such notice be issued by registered post, fixing a short returnable date. He further undertakes to take steps for substitution of
Respondent number 1.
respondent number 1 who has died in the meantime. List this matter after service of notice on respondent number 3.
Item number 14.
May I plead your lordship? The present appeal, lordship, the sole appellant died. I have already filed an interim application for substitution of the sole appellant, lordship, but that is not come on the record. That is interim application number 729 of 2024, lordship.
This has already come, but you also come to the court tomorrow.
I beg pardon,
Second
lordship.
appeal I will not hear on virtual mode.
I beg pardon, lordship. I was in court. My learned was arguing a matter online, so I came to assist.
All right. That is no issue. I am keeping it. I am passing it over. You come tomorrow.
My
Appeal, serve a copy also.
my lord, in courts of the day, my colleague is there. I will solve within a minute.
You have not received, Mr. Naik, copy? Get a copy of the IA be served upon Sri Naik, learned counsel appearing for the respondents by tomorrow. List this matter next week. If you what is this petition for? For substitution, what do you have to say about it?
I have filed 2 applications, my lord. One is for realization of arrear house rent, another is for vacation of stay.
Vacation सुनानी तो करता final सुन लो vacation कौन vacation को ढलेंगे List this matter next week, okay? And come to the court.
Obliged.
Item number 15.
Pass over.
Item number 16.
16, my lord, the other day I saw the copy on my learned friend who is on virtual mode. The application for permission to appeal, leave to file appeal.
Item
It was not implemented as a party, though the land recorded in the name of the state.
This is a formal thing, sir.
Item
Wanted copies I have given. The delay condonation.
Item 16, lordship. I humbly pray, lordship, I take up on Thursday. I am filing an objection by delay of 4 years.
All right,
Both
pass
the
over.
interim application. I will
All
file
right, pass
objection.
over, pass over, pass over.
Fine. I'm up.
Item number 17.
Item 17, Miller. I am appearing for the appellant, so lordship kindly see the noting.
Memo
filed, but that person has never requested me for return back. Therefore, your lordship either
I'll call him. Let him appear.
Yes.
Let him appear.
Yes, let him appear, Miller.
Fazilem chalche na. a memo has been filed on 2/5/2024 purportedly by the petitioner bracket apparent local. An affidavit has also been filed by Ramlal Lohar, who is the appellant number 3 in the case. It is stated that the memo of disengagement of Sri B.S. Panigrahi advocate dated 6/12/2023 be accepted. And the Vakalatnama executed in favor of another counsel be accepted. Why don't we settle it? Yes, Mr. Rautre. What is this?
Well, I have no objection if the brief is returned back. But that allegation will be kept on record forever.
He has not made any allegation. He has not made any allegation. So the thing is that why affidavit? Affidavit দেওয়ার কোনো দরকার নেই। Affidavit দেওয়ার কিছু আবশ্যকতা নথিলা। Between lawyers, either of you who does, how does it? Let him do No, but he has filed an affidavit as I'll have to deal with that affidavit. Na? I'll have to deal with that affidavit. So let him appear.
Let him appear.
Let him appear. In the favor of another lawyer. Sri Panigrahi submits that the client had never approached him to return the brief. Yeah, stop. In such view of the matter, issue notice to Ramlal Lohar, bracket appellant number 3, directing him to appear in person before this court. On good date करो 2-3 सप्ताह छड़ी 29th July पूरा supplementary करो supplementary करो on 29th July in the supplementary list to explain the circumstances under which he filed the affidavit. Yes, office to do the needful forthwith. Yes.
Here I am entered appearance to the respondent number 1. I would like to file objection to the continuance of petition.
Objection to the
Delay.
What, Mr. Das?
Se poisra jau 12 session. Kichi diyantu.
देखियो कितने दिन delay?
More than a year. He has taken the plea that COVID period. I don't have an objection. If some amount is reported in the welfare of
we'll see.
COVID period.
नहीं कोविड पीरियड में किछ होबन किछ होबन
मु बाहर को जाओ
नहीं बाहर को कहीं जाओ बाहर को कहीं जाओ कोविड पीरियड वाला होबन यस आइटम नंबर 18 yes
application for delay is filed.
Notice has been issued.
Yes, notice has been issued.
Nobody has appeared.
Your Lordship, I am for the respondent.
Yes, कितने delay?
Lordship, there is a delay of 2 years.
2 years.
My lord, in between that COVID period, my lord, that date I have mentioned in my petition itself.
Impugn order is passed on 21/1/2020. So the cause of action falls during that March 2000, after that March 2020.
And it continued up to December 2021, this COVID period. And this appeal memo is prepared on 25/1/2022, just one.
Office has pointed out delay of 1384 days. It is, however, stated that the impugned judgment was passed on 21/1/2020. Shortly thereafter, the restrictions on account of COVID-19 pandemic were imposed. So, as such, the prescribed period for filing of the appeal fell during the said period. In view of the decision of the Supreme Court in the case of regarding condemnation of delay, the cause of action for filing of the appeal should automatically extended. The time to the time stood automatically extended. The appeal having been filed on 27/1/2022, this court is inclined to take a lenient view. The delay in filing of the appeal is condoned. List this matter for admission. Okay,
Your Lordship, I am filing the gain on behalf of the respondent.
please. The week commencing 20th August. Your good name?
Manoj Kumar Agarwal.
Manoj Kumar Agarwal. Shri Manoj Kumar Agarwal, advocate and associates have entered appearance for opposite party number for the respondents. Yes.
Just sort that admission.
Yeah, 2022 happen.
Item number 19. May I please, Your Lordship? My sole appellant is died and I filed an IA for substitution of the legal heirs. It's died on 20.
Respondent number 9, 8A and 8B.
One appellant.
Sufficient. आगे सेटा करा दो.
Respondent number 3. Sebi merge.
Yes.
Appellant to sole appellant भी merge होती substitution file करें और respondent number 3 भी तांको भी substitution file करें.
But a copy. No, first we will deal with this notice part. Notice issued on respondent number 8 small a, 8 small b, and 9 is held to be sufficient, being personally served. Notice on respondent number 8D is also held to be sufficient, being received by his mother. How many? Respondent number 6 or 7 कौन is देखे? Postal tracking report. कौन postal tracking report कहला? Where is the postal tracking report? Track consignment flag है. The postal tracking report indicates that the notice was duly served. Hence, notice on respondent number 6 and 7 is also held to be sufficient. Fresh notice we issued on respondent numbers 4 small a and 4B. You take fresh notice again.
Yes.
By register post with AD. Fixing a short returnable date, requisites be filed within 3 working days. Respondent number 4, A, B, C, and D. Hala, same. You take fresh notice regarding the delay matter, isn't it?
Yes, ma'am.
On substitution, you have filed 3 petitions, isn't it? These 3 petitions relate to whom? The appellant.
Appellant.
के भाई delay कितने दिन नहीं?
Delay 5 वर्ष. Date 24 22 23 से मोल में हम फाइल करचो 29 ना 23.
5 मास.
Copy maybe copy टा देना.
कंट्रोल करेगी तो ये कर दोगे आपको. कोटा डिले पिटिशन था भीतर 3टा भीतर कोटा which one is delay?
First delay
कितने 1089 ना 1088
1087 टा हला 1086 रो. Appellant sole appellant delay condition. Our respond number 3 हला
1087 है.
1090.
This is application for condonation of delay in filing of substitution petition in respect of appellant, the sole appellant who died. It is submitted. It is stated that the appellant died on 22/4/2023. His legal heirs could not take necessary steps because of unavoidable circumstances. In the process, there has been delay of nearly 5 months in filing of the petition. Considering the ground as cited, this court is inclined to condone the delay. So, the delay in filing of the substitution petition is hereby condoned. तापर तार हला 1086 टा ना
1086
1086 रे लिखिबे
1089 ସେଥିରେ ହେଇଛି
ନା 1086 ଟା appellant ର ନା
appellant ର ହେଲା 1086 ଟା
ସେଇଟା କରିଦେବା ସାରଦ It stated that the sole appellant died on 22/4/2023, leaving behind his legal heirs, whose details have been indicated in the petition as one small a to one small d. So, it is further stated that the right to sue survives in respect of the legal heirs. As such, the petition for substitution is allowed. The legal heirs of the deceased appellant be substituted in his place as respondent numbers 1A to 1D. Consolidated appeal memo be filed within a week. Yes. ମୁଁ ରେସ୍ପଣ୍ଡେଣ୍ଟ କହିଥିଲି କି
ନା ରେସ୍ପଣ୍ଡେଣ୍ଟ ଆପିଲେଣ୍ଟ ମାନେ ସୋଲ ଆପିଲେଣ୍ଟ
ହଁ ସୋଲ ଆପେଲେଣ୍ଟ ତ କହିଲି ଆପଣ ସୋଲ ଆପେଲେଣ୍ଟ କହିଲେ ତ
ୟେସ୍
ହଁ ସେ ତ ସୋଲ ଆପେଲେଣ୍ଟ
ରେସ୍ପଣ୍ଡିଂ
ୟେସ୍ ତାପରେ ବାକି ଯୋଉ ତିନିଟା କଣ ୟେସ୍ ତାଙ୍କର ଆବେଟମେଣ୍ଟ ନାହିଁ ସେଇଥିରେ ପକେଇ ନାହାନ୍ତି ସେଇଥିରେ ଯିବ ଭାରି ସେଇଥିରେ ଦ୍ୟାଟ୍ ଅର୍ଡର ୱିଲ୍ ବି ପାସ୍ଡ ସେଟା ସେ କରିଦେବେ ନାଇଁ ନ ଯୋଉ the order of abatement is set aside. ମୁଁ ତାଙ୍କୁ କହିଲି ଇଏଟା ଡାକିଦେଲେ ଯୋଉ ପଏଣ୍ଟ ଡାକିଦେଲେ ସେ କରିଦେବେ ଏଇଟା କଣ
ଆବେଟମେଣ୍ଟ ଫାଇଲ ହେଇଛି 109 IA 1090
No, I have seen it, sir. He will take care. Respondent kiye? Respondent kiye mari? Respondent number 3. You are appearing for respondent?
Respondent number 1.
You said that respondent number 3 died on 13/4/2023. Delay confirm kar do. Yes. Same that consolidated memo we filed. Anything else in this? Anything else? Any other petition?
No.
All right. Huh? Let's this matter in the week commencing 20th August.
No. I don't know 20.
I'll come in a minute. Just 1 minute. Effect be removed within 3 days peremptorily. No later we dismiss you. Is this matter next week?
Some more time maybe when I have to sort for certified.
You have been given a lot of time, I find. Yes.
Item 21.
That's all.
Item now 22.
Your Lordship, I'm appearing on behalf of respondent number 1A and 1B, Your Lordship.
Yes. Notice on respondent number 2 bracketed small a being refused, the same is held to be sufficient. Postal tracking report be tagged to the case record. In respect of the notice issued to respondent number 2 small b, is this matter next week?
Interim order.
Interim order to continue.
Interim order nahi. Interim order ta interim application ta pending achi. Seটা let it be listed next week.
Next week that's it.
Item 23.
Please, my lords. Here, on 1/5/2024, this court admitted the appeal on the ground that whether the learned lower appellate court committed an error in ignoring the settled position of law that exclusion of time as provided under section 14 can be made applicable to appeals. Now, here, if your lordship would see page 18.
Here, notice has not been completed. Just the noting. Notice on appeal matter not completed. That we have to see.
Complete.
Service
Complete heichi beli achi na. My friends are appearing. Item number 23.
23 tha?
23. In the list, the noting is notice on appeal matter completed.
Okay.
The not is not.
LCR not received.
LCR is not received. It's a short point, my lord.
LCR is not necessary.
Not necessary. The question is this, My lord, may see paid.
Who's the other side?
My learned senior, Mr.
Yes, Mr. Barik, you are there.
Oh, now you have. Item 23 is 23. 23. Oh. Let it come on some other day. Because
I'll pass it over.
I have just appeared.
I can pass it over. It is for the entire week. This is the only
not
point.
gone through the brief. My lord.
It will come there next week also.
Understood.
You have filed Wakalatnama or?
I have filed the Wakalatnama, but I have not.
CPR Barik has entered appearance for the respondent. His name be reflected in the cause list.
Name is also reflected. My name is there.
Okay. No, name is there.
Yes.
Acha. CPR Barik requests for a short adjournment. Let's this matter next week. We'll take it up for hearing then.
My lord, it's a short point. And there's
For
a
hearing,
judgment also of the Supreme Court.
All right.
Sir,
Item 24.
24.
24 also I have appeared for the respondent.
Yes.
I am for the appellant. Matter has come for orders, madam. Last occasion, Lordship had admitted the appeal and called for the HCR. And had granted an interim order for stay order.
There's an interim order. There is an interim order. Passed on 1/5/2024 that there shall be no alienation of the suit property. So what do you want now?
It has come for orders, Lordship may take it up for hearing, madam. On it.
Yes. What do you say? LCRSC. LCRSC. It is a 2023 matter. Call for the LCR. List in the month of September.
Interim order to come.
Interim order to consider.
Item 25. 23. I am for the appeal. Madam, in the previous occasion, I have expressed that
you filed
material evidence available on the record has been
yes
ignored.
What?
25 item.
In
the previous occasion, I have explained before your lordship that material evidence available in
No, there is another IA you have filed for exemption from paying the court fees. Some order has to be passed.
My lord,
IA 530 503. You were exempted in the court below.
Madam,
where is that order?
Madam, decree nahi
Yes.
It is. I don't know if Chandramani Samal and Kalyani Raut. I have not got the copy of the.
Kalyani Raut is a lady. So she is exempted.
She is exempted. There is no problem.
Appellant number 1, he claims that he is under low income group.
No, below income group.
So ସେଇଟା ଯଦି ତଳ କୋର୍ଟ ରେ ହେଇଥିବ
ତଳକୋଟରେ ହେଇଥିଲେ
ଡିକ୍ରିରେ ମେନସନ କରିବା କଥା ମେନସନ
କରିନାହାନ୍ତି।
ଡିକ୍ରିରେ ମେନସନ କରିବା କଥା ଯଦି ଲେଖା ଥିବ କୋର୍ଟ ଫି ପେଡ୍ ବୋଲି
ନାଇଁ ମେନସନ ହେଇନି
ହେଲା
ମଡିଫିକେସନ କରିକି ଆଣି
ସେ ଛାଡ ହେଲା ଆମର କିଛି
ଆଣିଲେ ଆପଣ ମଡିଫିକେସନ କରିକି
ଆଣି
ଆଣୁନାହାନ୍ତି। Let him obtain that.
Lord, the problem is, Lord, your lordship, kindly, a lady, your lordship, she is Sashikanta Samal. What is her age? 74 by the time. According to them, even they say that the husband had purchased the property in the name of wife, Sashikanta Samal. That is their stand. But what this son and his wife, they have done, that these old persons, they are staying in a rented house and at the mercy of the local people, despite the fact that he had constructed the house, they were staying, they were subjected to torture. The old parents, they were driven out from the house and they have a decree to enter inside their own house.
No, I wanted to see the sale deed. There is an order I have passed also.
Your lordship wanted, just because it was before the summer vacation, your lordship directed that they list the matter on 18th June on the reopening, so that during the summer, nobody should be put to any kind of trouble. But the appeal has not been admitted, nothing has been done.
No, that is true.
And this Kanti Samal, the finding is of the both the courts below that it is her absolute property.
Oh, but that I will see, but it
Your lordship will see definitely, my lord. I would do have that much of faith. But the question is that I drew your lordship's attention to the age of these parents and how they are tortured and they are remaining outside. And for the
Now I'll grant you 2 weeks time to obtain a modification of the decree. Otherwise, how will this court come to a conclusion that, and unless the court fees are paid, the appeal is technically not ready for consideration. That is the problem.
2 weeks time.
It's 2023 matter.
Times.
Eh?
3 weeks. 3 weeks time.
Well, that way the matter will be, because I had entered on a caveat, because
I understand your anxiety, but there will be
it will continue for me, lord. That is the reason. For 2 weeks these things will continue.
No, but how? Otherwise, the only thing that can be done is appeal can be dismissed in respect of appellant number 1. But so far as 2 is concerned, she is exempted. Joint appellant, nahi? So no, हमें ऐसा करेंगे 2 weeks time दो. It is submitted that the appellant number 1 was exempted from paying court fees in the court below. The decree does not indicate so. Then counsel for the appellants prays for some time to get the decree modified by the court below. Place this matter in the week commencing 29th July. That's all. जाकर रहेगा तो करिए ना dismiss हो.
अरे interim order में continue.
Interim order to continue till then.
Item 26.
26. Stand to court. Shall be in delay. What is your issue notice? आइए रहे ना? Issue notice to the respondents by the respondent. Johnny. Respondent by registered post with ID returnable within 4 weeks. Requisites be filed within 3 working days. Let this matter on
September. So in the week commencing 2nd September.
in the week commencing 2nd September. Yes.
Item 27.
next week मेला hearing. अरे ते कागजपत्र पढ़ी है नहीं
No, it is it has out of 11, my lord. It should come for hearing. Hearing. Yeah. It has been admitted. Admitted long back, madam. So wrongly it must have been listed.
Can you see the order? Lordship may kindly see.
Admitted since 1999-2022,
my lord.
All right.
Subsequent questions are also accepted.
Therefore, adjournment is made on behalf of the respondents.
Number 1.
Substitution matter is complete.
My lord. That is all accepted. Sufficient, my lord. My lord, kindly see note.
Consolidated appeal memo will be filed. So list this matter for hearing in the week commencing 5th August.
In the meantime, consolidated appeal memo.
So I have filed. That way I have given.
No, not given.
I have sought the court also to be.
No, ଦେଇଥିଲେ ମୁଁ କଣ କହିଥାନ୍ତି ଯେ ପାଇନି ବୋଲି.
बेटा होता है कि सर another copy. Yes. Tomorrow. 5th August, my lord. Weekly in the week commencing 5th August for hearing. My lord, let it come to 12th August. 12th August, all right.
Okay.
Item 28.
In the meantime, I give the copy. I have given the copy in the court itself.
Item 28.
May I please, Lord?
But in this matter.
This is for admission.
Yes, Your Lordship. That the four.
Not been admitted so far.
No. Yes.
Bill has been condoned.
My learned senior Mr. Mishra is engaged in this matter. My lord, here the substantial questions of law needs to be reframed, my lord.
When was it framed?
No, reframed it has not been properly mentioned in the appeal memo. So
What is the memo you say? We will frame it.
my lord, yes.
Here's the matter.
Lordship, kindly keep the matter for the next week. Mr. Mishra was here due to some issues. He had to leave.
So the entire week is there. The week is there. You can take it up tomorrow, doctor, and order.
Yes.
Yes.
Tomorrow.
Yeah, Passover is okay.
Item 49.
The name of the Biroja Prasad Satpati, bracket as his lordship then was, be deleted from the cost title. है ना? Passover.
I don't know.
नहीं, Passover next week. This is not next week. Item 30. Passover.
Item 31.
In this case, the appellant challenge their both courts order that is a confirming judgment. Actually, my lord, the respondent has no right title, interest and possession of the case land. Admittedly, predecessor appellant purchased the case land through registered deed, and it was also mutated before the settlement proceedings. But one things, GA registered deed रे मतलब सीए मोते न कोई सबरेस्टम से कैंसिल कर देता था सक्सेसर जो को बिक्री कर दिले से फाइनल पब्लिकेशन आरआर को बोर्ड ऑफ रेवेन्यू की सिविल कोर्ट रे चैलेंज न कर तहसीलदार पाखे कर नेला सो आई फाइल दिस सूट इज dismissed. The appeal also mechanically dismissed. The substantial question of law, my lord.
रूम तो अपने तत्व वाले में धर पीरी नहीं गया तो रूम तुम्हारे टे बुझे जिनसरा कौन आ गया कौन सूट किए कौन तहसीलदार कौन कहले मु किछ बुझ पारनी
My lord.
कौन इतरा गया सूट कौन फैक्ट कौन इश्यू फ्रेम हला इश्यू रे फाइंडिंग कौन हला
My lord, the substantial question of law, para 3, page 20.
सर ठीक है ट्रायल कोर्ट जजमेंट को आसन तो ये ट्रायल कोर्ट जजमेंट को आसन
My lord. Turning page.
Please complete the trial court judgment, Mr. Solangi.
My lord.
Please complete the trial court judgment.
Trial court judgment, my lord.
Let us see the issues.
Page 40. It's the fresh matter, my lord.
Hello. Unless I'm convinced, I confirming judgment.
My lord, running page 44.
Yes.
To my lord. Have the plaintiff any cause of action?
No, issue number 4 to the hello. Issue number 4 finding the one.
Have the plaintiff any right title interest and possession over the suit land? Have the defendants any right title interest and possession over the suit land? Sixth number, is the suit property is valued? Are the plaintiff is entitled to be decreed for a permanent injunction as so sought for? To what are relief, if any, the parties are entitled? That is the issue framed by the trial court.
You are the plaintiff.
I'm the plaintiff.
The court, trial court holds that you have no right title interest over the suit land.
My lord, kindly see, Exhibit 1 is a finally public hours. Mu jota purchase kali, seta settlement re mor hegla. Finally published RR challenge before the civil court within 1 year, 3 years, or board of revenue for 1 year. Tahsildar has no locus standi to cancel my finally published RR. I wrongly challenge. যদি ମୁଁ appeal କରିଥାନ୍ତି ସେ କିଛି case ନଥିଲା but the petitioner wrongly challenged before the civil court declare right title interest possession over because dependent is a gunda nature and threatened to dispose. This is a case. Actually, the respondent has no right title interest and possession over the case land. The substantial question of law, my lord, I will mention that is a para page 19, para 2, para 3 and 4. Both orders are perverse, my lord.
How?
My lord, para 3, both the courts below have acted contrary to law in examining the genuineness of Exhibit 2, certified copy of a registered lease deed. If one recorded tenant to transfer the lease deed and that deed also mutated before the settlement authority, that is finally published RR, Exhibit 1, Tahsildar has a local standing to cancel and mutated the case land and successor basis.
The OA authority after vesting
Vest କରିଥିଲେ ମୋ predecessor ନାଁରେ after lease deed OA authority ଯୋଉଟା ମୋ ନାଁରେ vest କରିଦେଲେ ସେଇଟାକୁ settlement କରିନେଲା ତହସିଲଦାର ଯୋଉ ଲୋକେ ଷ୍ଟାଣ୍ଡି exhibit really is a void ab initio ତ ସବୁ ତହସିଲଦାର ମାନେ କରିଦେବେ. So it is a law is very subtle. A registered deed earlier ସବୁବେଳେ valid. Later nothing. Till date also I am paying rent, my lord. Para 4. This one, both courts below are acted contrary to legal law in plain and fraudulent nature. Preparation of Exhibit A. In the pre-publication matter, Tahsildar has no competency to interfere in the final publication order, for which the order dated Actress Branch 1980 in the mutation case 1501 is void ab initio.
Good one.
So, heard Sri A.K. Sarangil and comes to the appellant. Appellant or appellants?
Appellant is ordinary.
Appellant. There is the judgments.
Appellants.
Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the courts below were correct in holding that the Tahsildar has competency to interfere in the final publication of ROR.
My lord.
Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR, list this matter on.
In the week commencing 27th August.
In the week commencing 27th August. Yes.
What are you actually?
Status quo as on date with regard to the suit property shall be maintained till the next date.
Item 32.
Lords, against the conforming judgment, Lords, the present appellant is the defendant number 4 in the courts below and appellant before the first appellate court, Lords.
You are the plaintiff.
No, I am the defendant number.
Who is the defendant?
My lords. Defendant number 4. Lords, plaintiff is the respondent number 1. Present respondent number 1 was the plaintiff. And the present respondent number 2 is the defendant.
Yes.
Defendant number 1. Lords, the defendant number 2 is the father of both the plaintiff and defendant number 1. And defendant number 3 is the mother of defendant number 2. Sorry, defendant number 1. Now, defendant number 2 is the father. Suit is, Lords, filed for Lords, declaration of the exclusive right title interest of the plaintiff, and the defendants have no manner of right title and interest. Second, plaintiff's possession be confirmed. If it is found that the plaintiff has been dispossessed, then possession may be recovered. Declaration that the ROR of major settlement recording the name of the defendants is wrong and illegal. And injunction against the defendants. Alternatively, if it is found that the suit property is liable for partition, then decree for partition may be passed. So there was an alternative prayer for partition. Here, my lords, may I submit one thing, that the plaintiff himself is not sure about his right. though he has claimed his exclusive right over the suit schedule property, but in the alternative, he has prayed for partition, my lords, because, lords, the suit property, father, the defendant number 2, lords, he had married first to one Malati, my lords. Malati is the mother of the plaintiff. And defendant number 1, subsequently, the defendant number 2, the father, married to Suma after the death of Malati.
Yes.
First wife is Malati and plaintiff is the son of Malati. Lords, after the death of Malati, the defendant number 2 married to Suma. And the defendant number 1 is the son of Suma.
So stepfather, stepbrother.
Stepbrother. Yes. And
Then-
Malati and Suma are two sisters. There is no dispute about that, lords. Now the property was purchased by the defendant number 2 in the name of Malati.
মানে সাপোর্ট বোন না রে
No, from first wife na.
আচ্ছা ফার্স্ট ওয়াইফ না স্যার
First wife na back So thereafter, subsequently, some property was also purchased by the defendant number 2 father in his name, which is claimed by the defendant that it is purchased from the outcome of the property of Malati. Therefore, it is the exclusive property of Malati. That was the claim. Now, lords, subsequently, the father, defendant number 2, he has executed 2 gift deeds. There was dissension between the wife of plaintiff and the stepmother, Suma. So therefore, there was a document was executed, 2 gift deeds were executed. One is in the name of the plaintiff, father has executed, and another is in the name of defendant number 1, the 2 stepbrothers, lords. Now thereafter, both the brothers, the plaintiff and defendant number 1, they have executed separate sale deeds in the name of some other persons, lords, 2 outsiders. Now I am one of the purchaser from the defendant number 1.
So what happened? The suit was decreed.
It was decreed, and thereafter, lords, appeal. I have referred appeal.
What is the wrong finding? What is the
Finding, lords, your lordship may kindly. The finding is on the basing on the presumption that when the gift deeds were executed at that time plaintiff was 21 years old. Now the trial court has held, lords, at page 16 of the trial court's judgment, running page 63 minutes.
Yes.
Lords, towards the bottom, according to the exhibit 3, trial court's judgment, lords, page 16. Lords,
yes.
According to the exhibit 3 is the school admission, lords, certificate, school certificate of the plaintiff. According to the exhibit 3, if the date of birth of the plaintiff is in the year 1946, then he will be aged about 21 years. At this stage, it is natural that he had no idea about the landed properties. As because he was residing with his father, is looking after the same. My lords, basing on this presumption, it is held that the recording in the settlement record of rights, lords, after the gift deeds, lords, records were also prepared separately in the name of the plaintiff and defendant number 1. Now the trial court has held that at the age of 21, he might not have known about the landed properties, and it has been wrongly. And the trial court has held that it is the self-acquired property of Malati, and the defendant number 2, the father, as well as the defendant number 1, they have no right title interest over the property, and it is the exclusive property of the plaintiff.
So what happened in appeal?
Appeal, it is confirmed. Appeal also, same finding in the appeal also.
Let us see. All right, admit it. On substantial question number C and D, my lords. Heard Sri, sir, your good name?
Hon'Ble Ponda.
Sri A.C. Ponda, Learned Counsel for the appellant. Appellant.
Appellant, my lords, one.
The appellant.
So the appellants.
What is the improved judgments? Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Only C and D will, I think, do,
My lords.
isn't it? The following substantial questions of law, C and D, page number 20.
B is also same, my lords, based on presumption.
C and D बेरा कोई
No, B, my lords.
इसी C रो अरेंज करी बनी C रे डिस्कस कला लोग सीधे ऑटोमेटिक प्रिजम्पशन कथा ता ऐसी जो का knowledge of the registered document. When you are talking of the registered document, the presumption that he has drawn will automatically come into picture. So तापे specifically frame करा जाता है. बाकी fraud कथा जो movie देखो तो whether they are pleaded and proved or not.
Yes.
Pleading is required.
Pleading is required.
Right. Yes. The respondent, you are appearing for all the respondents.
Only the first is.
Respondent number 1. So notice has to go. Respondent number 1 has already entered appearance through Sri Prafullo Kumar Ratha. What is your name?
Yes, thus.
Yes, Das. No notice need be issued to respondent number 1. However, issue notice to the other respondents by registered post with ID, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter in the week commencing September. 2nd September. IA notice as above.
Lords, status quo was there all along, lords, in the appeal also status quo was there.
Now, let us see. Conforming judgment, what status quo?
There was, lords, there was order of status quo.
Yes, what do you say?
Chip, since we are already in possession of the decree,
So status quo won't hurt you?
it won't.
All right. Status quo as on date with regard to the sub property be maintained till the next date.
So item 51.
51, you.
Next week also there is some difficulty. Interim order.